banking.
Money, banking, and trust by moving titles in commerce. Featuring NTT, New Trust Technology. Presenting your host, Christian Walter.
I'd like to welcome everybody to this welcome everybody to this Tuesday, July 13th, 2010 edition of Money Banking by Moving Titles in Commerce. I'm your host, Christian Walters, and welcome to NTT as New Trust Technology, and we'll go to the disclaimer next. Take notice agreement that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or implored for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. Again, I'd like to welcome everybody to this Tuesday, July 13th, 2010 edition on Money, Banking, and Trust. Welcome to NTT. We started a new book. We're in Corpus Juris Secundum, Book 90. And we left off yesterday at page 68, section 180, which was the extent of estates or interest of trustee. So that's page 68, section 180 in general. Subject to some exceptions at law, the legal estate in the trustee possesses the same properties, characteristics, and incidents as though he were the absolute owner. Under some statutes, the trustee is vested with the whole estate, subject to the execution of the trust. Where the use is executed, the trustee takes no estate or interest, as discussed supra, section 176 and 178. But where the use is valid and not executed, he is vested with the legal title as considered supra, section 175. In that law, the legal estate in the trustee possesses the same properties, characteristics, and incidents as if he were the absolute owner. The trustee, however, has been termed a mere depositary of the legal title, but a power that may be exercised. Under some statutes, the trustee takes both the legal and the equitable title, and the beneficiary only the right to enforce the performance of the trust. And under such or similar statutes, the trustee is vested with the whole estate, subject to the execution of the trust. The vesting of the title in the trustee is not affected by a reservation by the settlor of the power to terminate the trust or to control investments under certain circumstances. And the fact that the trustee cannot sell without consent of the beneficiary does not destroy his power of disposition so as to deprive him of the legal title. Trustee has no superior rights with respect to the property than his grantor, and any circumstance that operates against the grantor would bar the claim of the trustee. The trustee may convey the interest which he may have individually in the subject matter of the trust, but he must not substitute another in his place as trustee without the consent of those interested. The trustee cannot hold a legal title to an estate or a fund, an absolute title which is vested in another. Beneficial interest, next section. If a deed is expressly and expressively intended to create a trust, it confers on the trustee no beneficial interest, and after the trust is terminated, the trustee cannot claim to be the beneficial owner of the trust held in trust unless this clearly appears to have been the intention of the settlor, but he will have a beneficial interest if such is the apparent intention. Next section, innocent purchaser for value. Where a trust conveyance is in consideration of love and affection, the trustee is not an innocent purchaser for value. Next section, descent of estate on death of beneficiary. It has been held that on the death of the beneficiary without heirs, where there is no reversion to the grantor, the trustee will take the whole estate. Next section is commensurate interest. Number 1, with the estate of beneficiary. A trustee and trust deed holds for each city key trust just so much estate as each city key trust would have held under a deed in the same terms but providing for no trustee. A trustee and a trustee holds for each city key trust as so much estate as a city key trust would have held under a deed in the same terms but providing for no trustee, and the trustee takes legal estate commensurate with the equitable estate. 2, with purposes and duties of trust. A, rule stated. In general, whenever a language by the trust estate is vested in the trustee, its nature and duration are governed by the requirements of the trust. In general, whatever the language by which the trust estate is vested in the trustee, its nature and duration are governed by the requirements of the trust, and in equity the extent and quality of the trustee's estate is commensurate with and dependent largely on the purpose of the trust and the duties imposed thereby on the trustee as expressed in the terms of the instrument creating the trust. The trustee takes exactly that quantity of interest, whatever it may be, which proper execution of the trust may require, and no more, and even though granted to the trustee to the fullest extent, the legal estate will not be carried further than the trust requires. A sufficient estate will, however, if possible, be implied. The principle that the trustee of a trust estate or express trust of real property takes only such an estate as the requisite to enable him to carry out the terms of the trust applies also, and by analogy, to express trusts of personal property. B, vesting a fee. A trustee takes a fee if the intention of the grantor to convey it is plain, or if it is necessary for the execution of the trust. The trustee takes a fee if the intention of the grantor to convey it is plain, or if it's necessary for the execution of the trust. But in the absence of evidence to show that the vesting of the fee is necessary, the court will not presume that a fee was intended. A trustee will imposing the duty to convey the fee is held to confer the fee on the trustee, but a trustee may have a power of sale over the entire fee and yet have no interest whatever in the legal estate in remainder, except with the limitation that he may, in the exercise of the power of sale, defeat it in the particular property. Where there is no purpose to be accomplished by the longer continuance of the trust, only a life estate vests in the trustee. Next section, words of limitation or inheritance. The legal interest of the trustee is not measured by words of limitation or inheritance in the deed or will. The question being whether the exigencies of the trust demand the fee simple, and the trustee will take the fee without words of limitation or inheritance when necessary for the trust, and where the purposes for which a trust is created by a deed or device of land are of such a nature that they do or possibly may require a legal estate in the trustee for a period beyond his whole life, or where an absolute power to sell and convey realty is vested in the trustee. A fortiori, the trustee will take the fee if necessary if there are words of limitations or inheritance. Conversely, only the limited estate required by the trust will vest, although the language of the instrument conveys to the trustee and his heirs forever. A gift to the trustee or personal property without words of limitations vests in him the whole estate subject to the trust. Next section, 180, estoppel of trustee with respect to trust title. A trustee accepting the trust is stopped to contest the title of the creator of the trust to the property conveyed to the trustee, or to deny the title or estate of the person for whose benefit the trust was created or for whom he holds it. A trustee accepting a trust is stopped to contest the title of the creator of the trust to the property conveyed to the trustee and to set up a claim to the trust estate as against the beneficiary under the trust, or denying the title or estate of the person for whose benefit the trust was created or for whom he holds it. But this rule does not prevent the trustee from testifying as to a promise to convey made by the settlor to another. Next section, 182, adverse possession. Adverse possession by the trustee or his grantee against the city key trust is discussed infra section 183, by the trustee against the remainder men or the heirs or divisees infra section 184. Examine pocket parts for latter cases. Next section, 183, by trustee or his grantee against city key trust. A, by trustee against city key trust. Number 1, where city key trust in possession. A statute of limitation does not run in favor of the trustee against when the latter is in possession of the trust estate. Whether the trust is be expressed or implied, the statute of limitation never runs in favor of the trustee against the city key trust when the latter is in the possession of the trust estate. 2, where city key trust is not in possession. A, express trust. During the continuance of a trust relationship under an express trust, the possession of the trust property by the trustee is not averse to the city key trust, and so the trustee cannot assert personal title by adverse possession. The relationship of privity between the trustee and the city key trust in an express trust is such that during the continuance of the relationship, the possession of the trust property by the trustee is not adverse to the city key trust, and so the trustee cannot assert personal title by adverse possession, and no length of possession of the trust property by the trustee will operate to bar the trust. The trustee may, however, hold adversely if he openly disavows and repudiates the trust, and the beneficiary has either actual notice or the acts or declarations of the trustee asserting title in himself are so notorious and unequivocal as to raise a presumption of a notice to the beneficiary, and the statute of limitations will begin to run from the time the beneficiary receives such notice, and in at least one jurisdiction it has been held that the trustee cannot adversely without first surrendering the possession of the trust estate, and the statute of limitations may commence to run after the trust ends or has become executed. But even though the trust has become passive, if the trustee continues to pay over the rents and profits of the land, it cannot be said to be a holding adversely to the beneficiary, since his possession is not hostile. A mere failure to execute the duties imposed by the trust will not set the statute of limitations in operation. Next section, B, resulting trust. It has been held that the rule accepting express trust from the operation of statutes of limitations is not applicable to the resulting trust, but there is other authority holding that where the trust is not repudiated by the resulting trustee, the statute of limitation will not bar the city key trust. It has been held that the rule accepting express trust from the operations of statutes of limitations is not applicable to resulting trust, since it does not involve confidential relationships between the trustee and a city key trust. But there is other authority holding that where the trust is not repudiated by the resulting trustee, the statute of limitations will not bar the city key trust. The statute will run in favor of the trustee of the resulting trust from the time he disavows the obligation of trust and sets up a claim in his own right to the trust property. C, constructive trust. The statute of limitation runs in favor of constructive trustee as against his city key trust. Adverse possession will run in favor of the constructive trustee against his city key trust when the latter is not under some disability. As between the trustee and beneficiary of a constructive trust, the statute of limitation begins to run against the enforcement thereof from the date of its inception, unless there has been a fraudulent concealment of the cause of action. No disclaimer or disavowal of the trust by the trustee is necessary. Next section, B, by grantee of trustee against city key trust.
where the trustee wrongfully sells or otherwise disposes of the trust property to another, the possession of such person is adverse within the meaning of the statute of limitations, and he is entitled to protection. Where the trustee wrongfully sells or otherwise disposes of trust property to another person, the possession of such person is adverse within the meaning of the statute of limitations, and he is entitled to its protection, at least where there is no limitation of subsisting trust in the deed of conveyance, and the trustee, or the grantee does no act which recognizes the existence of the trust. And this has been held to be true even though the grantee takes with knowledge of a trust, but there has been held that in such a case he cannot set up a title under the statutes in the absence of notice or knowledge being transmitted to the City Key Trust. It has been held that if the City Key Trust is under disability at the time of the irregular sale, he will be allowed the time within which to sue given the statute after the disability is removed. Such ruling being based on the principle that the trustee, by the instrument of sale, has stopped himself from suing, and the interests of the City Key Trust are thus unprotected. But there is another authority holding that the interests of a contingent City Key Trust is barred by adverse possession of the statutory period from the date of sale on the grounds that the trustee may avoid his irregular act by the proper action against the grantee. Next section, 184. By trustee against remainder men or trustors, heirs, or devisees. A. By trustee against remainder man. The possession of a trustee of a trust created for a life estate cannot ripen into a prescriptive title as against until after the lapse of the statutory period after the life tenant's death. The possession of a trustee of a trust created for a life estate cannot ripen into its prospective title as against the remainder man until after the lapse of the statutory period after the life of tenant's death. Next section, B. By trustees against trustors, heirs, or devisees. Where a trust is void as perpetuity, adverse possession of the statutory period of limitation by the trustee in favor of the City Key Trust will bar the claims of the residuary, divisee, or heirs at law of the trustor. Where a trust is void as a perpetuity, adverse possession of the statutory period of limitations by the trustee in favor of the City Key Trust will bar the claims of the residuary, divisee, or heirs at law of the trustor as long as the objects and purposes of the trust exist, or as long as it can be executed in substantial conformity to the provisions of the trust deed, after which it shall be held as resulting trust in favor of the heirs or divisees of the trustor, as discussed in Supra, Section 103, where the diversion of trust property for the uses to which it was conveyed causes it to revert to the trustor's heirs, the trustee may acquire title against the heirs by adverse possession. Section 185, creators of trustee. Subject to some exceptions, as a general rule, trust property is not liable for the trustee's individual debts, and this is true not only in express trust but also in resulting and constructive trusts. The trust property is not liable for the trustee's individual debts and cannot be reached by attachment or execution, and this is true not only in express trust but also in resulting and constructive trusts. The rule applies although the trust is oral, and unless a statute provides otherwise, or unless the trustee obtains credit by reason of the trust with the acquiescence of the beneficiary, even though the creditors have no knowledge of the existence of the trust, the estate being in the name of the trustee. On the other hand, it has also been held that if the record shows a beneficial interest in a judgment debtor, and there are no circumstances to rebut such showing, a bona fide judgment creditor may seize the property on execution, and the mere fact that the deed is in the name of the debtor as trustee will not rebut the showing under the statute, which provides that the grantee so designated may sell, convey, and grant the beneficial interest if no intention of the grantor is shown otherwise, or the declaration of the trust and the purposes thereof do not appear of record. A statute providing that no trust concerns lands shall prevent a creditor without notice of a trust from attaching them applies to lands held in life association as part of their emergency fund of a payment of a death and disabilities claim. Under a statute which invests the whole estate in the trustee, it has been held that the trustee who holds the legal title, although under a moral obligation to recognize another as an owner, cannot defraud his creditors by a reconveyance to a person for whom he holds the title. Next section, any beneficial interest. which the trustee has in the estate may be reached by his creditors. Next section, 186, express trusts. In general, the extent of the estate or interest of the beneficiary of the express trust depends on the intent of the creator of the trust as ascertained from the consideration of all provisions of the trust instrument. In determining the extent of the estate or interest of the beneficiary of express trust, the intention of the creator of the trust, as ascertained from the consideration of all the provisions of the instrument declaring the trust, must be given effect, if practicable and not contrary to law, as far as is consistent with the rules of legal construction, since in the construction of the limitations of the trust, courts of equity follow the rules applicable to legal estates. The City Key Trust takes the same estate and duration as though estate were legal instead of equitable. Thus, the City Key Trust may take equitable life estate, or dependent on the intention of the creator, he may take an equitable fee simple. The interest of the beneficiary of trust agreement may also be that of a tenant at will, and where a tenant conveyance in consideration for love and affection, the beneficiary is not incident purchasers for value. If property is given to trustees to be applied in their direct discretion to the use of a third person, no interest goes to the third person until the trustee exercises this discretion. Next section, real or personal property. Whether the interest of a beneficiary is an interest of real property or in personal property depends on the provisions of the trust instrument. Where the trust property is real property, the interest of the beneficiary is real property, unless the interest is so limited in duration that if it were legal interest, it would be personal property. Where the real property is held in trust, and by the terms of the trust, a duty is imposed on the trustee to sell it and hold the proceeds in trust or distribute the proceeds, the interest of the beneficiary is personal property, and this rule is applicable to participation certificates and mortgage bonds if the trustee, as the purchaser at the foreclosure sale, has the right to sell the property thus acquired and distribute the proceeds. The interest of the beneficiaries who have, under the terms of the trust agreement, no right, title, or interest in the realty as such, either legal or equitable, but only an interest in the earnings and proceeds with power to direct the trustee to deal with the title and manage the control of the property, and the right to receive proceeds from rentals, which right is to be deemed personal property, is personal property only and not real estate. B, vested or contingent interest, estate on condition. A beneficiary trust may have vested or contingent interest depending on the intent of the creator of the trust. The interest of the beneficiary of trust may be vested, while in other cases the interest of the beneficiary may be contingent or vested subject to being divested, depending on the intention of the creator of the trust as determined by the provisions of the trust instrument, and in each case must necessarily turn on its own face, or its own facts, The beneficiary may have a vested interest in the trust without having title, legal or equitable, to any specific property held in trust. So also the interest of the beneficiary may be vested, although the time of the enjoyment is postponed. The enjoyment of the beneficiary may be postponed in accordance with the plan intended of the creator of the trust, unless such intent contravenes some positive rule of law or is against public policy. Where the income is given and the corpus of the trust is to be distributed to the beneficiary in installments or in parts at different times, the inference is that the vested gift of income and corpus was intended. A beneficiary is not prevented from taking a vested interest in a trust by statute under which the whole trust estate vests in the trustee in law and equity, and the beneficiary takes no estate or interest in the lands, but may enforce the performance of the trust in equity. While the law favors the early vesting of estates, the time of vesting of the beneficiary interest is controlled by the intention of the creator of the trust, as expressed by the language employed, and other or general rules of construction becoming applicable only when the intention of the donor is rendered ambiguous by the language employed by him. The rule favoring the early vesting of estates does not require that a trust beneficiary's interest in a corpus of the trust estate be held vested where this contrary intention clearly appears from the trust instrument itself. Next section, estate on condition. An estate on condition may be created, and if condition is a condition precedent, the vesting of the estate is dependent on the performance of the condition. But if it is a condition subsequent, the estate vests immediately, and the non-performance of the condition renders it liable to be defeated. There are no technical words to distinguish these conditions, and whether they are one or the other is a matter of construction and depends on the intention of the party creating the estate. the performance or a condition subsequent, as in a trust deed conditioning a gift for life on the donee's remaining unmarried and living with deceased beneficiary, may be dispensed with if non-performance is caused by an act of God, such as death. The interest of the beneficiary may be forfeited for a breach of the conditions of the trust instrument and where the beneficiary contests the validity of the trust instrument. The estate of the beneficiary may be a determinable fee, a fee conditional, a conditional limitation, or a shifting use. Next section, C, several beneficiaries. The terms of the trust instrument are usually controlling as to the extent of each beneficiary's interest where there are two or more beneficiaries. Where there are two or more beneficiaries, the terms of the trust instrument are usually controlling as to the extent each beneficiary's interest. The general presumption is that where there are several beneficiaries, the intent of the grantor is that they shall share equally in the absence of a showing to the contrary, and where it is grantor's clearly expressed purpose that the beneficiaries be treated fairly and equally in the disposition of the trust property, a literal interpretation of the trust instrument which would defeat such purpose will be rejected in favor of interpretation in harmony with the grantor's intent. In cases in income where and principal are given in designated shares out of one fund kept in solido for mere conveyance of investment separate, the independent trust may be created for the several beneficiaries, and the shares and interests will be several even though the fund remains undivided. So where rents, issues, and profits were given in equal portions to 4 city key trusts for their lives, their respective portions to go to the respective children at their deaths, the children were entitled to intermediate possession of the property, and the use of which was limited to their parent on the death of the latter. Under the general rule of construction, the trust instrument may or may not operate to render the beneficiaries tenants in common. So also the trust instrument may operate to make beneficiaries joint tenants with consequent rights of survivorship where such intent is plainly manifested by the grantor. Next section, wrongful insertion of names. Persons whose names are wrongfully inserted in a deed as beneficiaries of a trust take no interest, and the trustee holds the property for the rightful beneficiaries. D, application of rule in Shelley's case. The rule in Shelley's case may be applicable to trust estates. While there is authority to the effect that the rule in Shelley's case has no application where a trust is created, it has been held that the rule, except where it has been abrogated by statute, applies to estates and trusts. The rule does not operate where the estate limited to the ancestor to the estate limited the heir or heirs of the body are of a different nature, and one being legal and the other equitable, so that they cannot unite. The rule does not operate where the estate is not limited to the heirs general or special of the same person to whom a preceding freehold is given or granted, or where a remainder is not limited to the heirs of the same person whom the life estate is given, and where the nomination of the heirs of the first taker as grantees of a remainder is a designatio personam and not a limitation, and for the reason that the word children is a word of purchase and not of limitation, where the remainder is the children of life tenant, the rule does not apply. Trust must be executed and not executory in order for the rule to apply, and in this contention, if a trust instrument requires a trustee convey, and it is presumed that the trust is executory and the rule does not apply, the heirs taking as purchasers under the trust deed. Where the owners of the realty become settlers of the trust, to pay income to them with the provision that the settler's death and the trust shall end with the realty shall become the property of the heirs, the rule of Shelley's case does not apply because it is distinct from the rule that the reservation to the heirs of the grantor is equivalent to the reservation of the reversion to the grantor himself. Under a statute providing that where express trust is created, every legal and equitable interest in the estate not encumbranced therein or otherwise disposed of shall remain in or revert to the creator or his heirs, where the trust instrument provided for the payment of a yearly sum to the grantor and gave the trustee power to sell or mortgage the property and provided on the death of the grantor, the trustee should convey the property to the heirs, and the heirs did not take by purchase, but by descent, anything left not being a vested remainder, but a reversion, and neither the rule in Shelley's case nor the statute abrogating it applies. It has been held that a trust deed for the grantor's children for life after the grantor's death, with remainders on the deaths to their issue and the latter's heirs, gave a child only a life estate and not a fee conditional under the rule in Shelley's case. Issue and lawful issue. Under a deed conveying land in trust for use of three named persons in fee to the survivor of them, which provides that if two of the beneficiaries die leaving issue, then to the use of such surviving issue who shall take per stirpes and not per capita, the word issue includes the grandchildren of the two beneficiaries whose parents predeceased them, and under the rule of Shelley's case, the fee will not, on the death of the other beneficiary, vest absolutely in a co-beneficiary, but on the death of either, the use shifts to his issue. Where the grantor does not use the word issue on a clause of the trust deed limiting a life estate to his children with remainder to their issue and their heirs as assigned forever, the technical sense of all future generations, the rule in Shelley's case does not apply. It has been held that where the words lawful issue are construed in the sense of the children or immediate descendants of life tenant do not in the sense of heirs of the body, the rule of Shelley's case is not applicable. Personal property. The rule in Shelley's case is inapplicable insofar as the trust deals with personal property. Next section, 187, power of appointment or disposition. The nature and extent of a beneficiary's power of appointment or disposition is usually dependent on the provisions of the trust instrument. General rules applicable to the exercise of powers apply where the interest of the beneficiary is coupled with a power of appointment or disposition, and in accordance with such rules, the nature and extent of such power is usually dependent on the provisions of the trust instrument. It has been stated that if the first taker under the trust instrument is given an estate in fee or for life, coupled with an unlimited power of disposition, the fee or absolute estate vests in the first taker, but that if the power is dependent on a contingency or is definitely qualified, the estate of the first taker is limited to life and the remainder overtakes effect. The failure of the City Key Trust to designate to whom the trust property shall go on his death will bring into operation such provisions as may contain in the trust for its disposition on the death of the City Key Trust, where the estate or interest taken by the beneficiary is of such character as, under general circumstances, it is divisible, and he may dispose of it by will. If the beneficiary of the estate is not invested with title thereto or control over during his lifetime, he cannot dispose of it by will or authorize anyone to intermeddle. Next section, 188, estate or interest of remainder men. A, general. The estate or interest in which a beneficiary takes under the trust instrument may be by way of remainder. General rules applicable to estates and remainder usually apply to trust estates. A remainder is created where a person other than the settlor is a beneficiary under the trust instrument and directly takes thereunder and not under the will of a settlor or under the laws of descent and distribution. There can be no valid limitation of the remainder on the absolute conveyance of the fee in trust. Cross remainders may be implied from the language used. The rule of interpretation favoring cross remainders to the survivor of the two concurrent life beneficiaries may be invoked by implication, but only in order to effectuate a manifested intention of the trustor to achieve that purpose. While the nature of the interest which a beneficiary of the trust takes by way of remainder is considered equitable, the amount or extent of the interest is ordinarily dependent on the terms of the trust instrument. Ordinarily, the gift to the remainder men is one of the entire corpus of the trust, as ordinarily treated at the time of the appointment for effectuation of his rights. In determining the beneficiaries who are entitled to take by way of remainder, the intent of the settlor of the trust must be ascertained from the provisions of the trust instrument. While a life beneficiary of a trust may also be the remainder man, whose heirs will take the remainder if the trust instrument plainly so provides. A conclusion so incongruous should be avoided where the language points to another direction. A person who is not being at the termination of the trust can in no event entitled to any part of the remainder or reversion. Next section. Whether the settler has created a remainder or reversion is dependent on his intentions as expressed in the trust agreement, and in this connection the entire instrument rather than an isolated portion of it controls. While the intention of the settler to create a remainder must be clearly expressed, the courts have been given weight to various factors to help in arriving at a proper determination. The presence or absence of the settler's control of the trust principle has been deemed important, and a lack of control, either in disposal except by will or an investment of principal, has been held to indicate remainder. It has been held that the reservation of the right to make a testamentary disposition of the corpus of the trust under certain conditions is not sufficient to defeat the obvious intention to create a reversion rather than a remainder. A direction by the settler of a trust to transfer trust property to the settler's next of kin is insufficient, and in of itself to create a remainder in the next of kin. There will be other indications of intention in order that there may be found sufficient or clear expression of the intention on the part of the settler to create a remainder to his next of kin. It has been held that a settler sufficiently evidences an intention to give a remainder to his next of kin, and where he makes a full and formal disposition of the trust property, makes no reservation of a power to grant or assign an interest in the property during his lifetime, surrenders all control over the trust property except for the power to make a testamentary disposition thereof and the right to appoint a substitute trustee, and no provision is made for return of any part of the principal to himself during his lifetime. B. Vested or contingent. A beneficiary's estate or interest by way of a remainder may be vested or contingent depending on the intention of the creator of the trust. The estate or interest in the beneficiary takes by way of remainder may be vested or contingent, or a vested estate subject to be divested depending on the intention of the creator of the trust as indicated by the provisions of the trust instrument. A remainder may be vested even though the enjoyment is postponed and even though the power of revocation or substitution might divest the beneficiary at any time of the right of possession which would otherwise pass to him on the trustor's death. The statutory provision which the state states a rule for the determination of whether an estate is vested or contingent has been held applicable to the trust estate consisting of personality. Since the law favors vested estates, the remainder will not be construed as contingent when it can be taken as vested, particularly where the intention of the settler is in doubt. A remainder cannot be vested where the remainder man cannot be ascertained, and where the remainder is the next of kin who are to be determined at the termination of the trust. If remainder men who are beneficiaries under the deed conveying a life estate in the premises are uncertain and unascertained, the deed should be construed as vesting the trust in the trustee with full title, and the title of the remainder man should be considered as abiding in him until they have been ascertained. The present interest of a remainder man as beneficiaries of a trust is no less real because the amount of the estate remaining undisposed of at the expiration of the particular estate is uncertain. Where a trust corpus becomes vested in the remainder man at once, subject to the trust, the survival of a particular remainder man until the termination of the trust is not a conditions precedent to such vesting. It makes no difference as to the vesting of the contingent remainder created by the deed of trust, whether the legal estate is in the trustees, who are required to convey and transfer it on a happening of contingency, or whether the deed provides for the interest to take effect without the intervention of trustees, where the futurity is annexed to the substance of the gift of the corpus of the trust fund, and the interest is contingent only, and the survivor at the time of the distribution is the essential condition to the acquisition of the absolute interest in the corpus. Unless a conveyance of the expectant estate in trust is based on the contingency that must inevitably happen, no vested interest in the future estate is created, and a person named therein does not become a beneficiary in law until the contingency happens. Where the property is held in trust, a beneficiary who is vested remainder man has no more rights of possession and control than a contingent remainder man, but each has acquired a property interest. Next section, time of vesting. While the law favors the vesting of estate at the earliest possible moment, time of vesting of a remainder in an estate depends on the intent of the creator of the trust as determined from a consideration of the provisions of the trust instrument. The fact that the remainder is not limited to the remainder man directly, but only the medium of the conveyance to him by trustee does not affect the principle regulating the time of the vesting of the estate of the remainder man, where a trustee contains a direction that the trustee shall convey the fee of realty on the death of the grantor to the person designated as remainder man. The trustee takes the legal estate and retains it as long as the purposes of the trust require such intention, and when its design is consummated by the death of the grantor, the real estate vests absolutely in the remainder man. Next section, C, acceleration of remainder. A remainder in the trust estate may be accelerated where a prior interest has failed or has been permanently terminated. A remainder in a trust estate may be accelerated in a proper case as where a prior interest has failed. On the premature termination of a prior life right and the rights of the preceding beneficiaries will be accelerated unless contrary to the intent of the settlor of the trust, and the rule usually applies if the possession and enjoyment of the fund by other beneficiaries is merely postponed for the benefit of the life taker of the fund, and also applies even though there is a substantial substituted gift to others should be consequent beneficiaries die prior to the death of the life taker. Next section, D, rights of remainder men and trustees. The ultimate beneficiaries of a trust estate have sufficient interest to protect the trust fund and to see that the fund is properly executed. The trustees cannot alter or affect the interest of the remainder men by their own acts. The ultimate beneficiary of a trust estate having sufficient interest to protect the trust fund and to see that the trust is properly executed, persons ultimately taking remainders under a deed of trust, directing payments of trust funds after the settler's death to persons appointed by his will, has his surviving issue, if any, or his next of kin take under the deed of trust and not through the settler's estate, whether or not the power of appointment is exercised. Trustees. The trustees cannot, by their own acts, alter or affect the interest of the remainder men, and they have no power over an estate in remainder except such as is given them by the trust instrument. Where the trustee is appointed for the life tenant alone, the trust deed does not appoint him trustee for the remainder man, or is silent on that point. He takes only that quantity of interest that is possessed by the life tenant. And the mere fact that the trustee is named to protect the property during the life of the life tenant does not make him a trustee for the remainder man named to take the fee after the death of the life tenant. But if the instrument creating the trust appoints him trustee for both the life tenant and the remainder man, he takes the whole interest in the estate. And in the former case, the remainder man holds the legal title and the trustee cannot interfere therewith. The latter, the remainder being equitable, he has full control over it as he has over the life estate. No representations of the trustee and life tenant, whether made for the fraudulent purpose or through a mistake as to the legal effect of the trust, can affect the estate of the remainder men. Where a deed of trust requires the trustee to convey the property to the remainder men on the death of the last surviving life tenant, legal title to the fee passes the remainder man on such death without a formal conveyance by the trustee. Next section, 189, estate or interest of beneficiary of spendthrift trusts. The extent of the estate or interest of the beneficiary of a spendthrift trust will be controlled by the provisions of the trust instrument. The general rule considered supra, section 186, that the extent of the estate or interest of the beneficiary will be controlled by provisions of the trust instrument applies to spendthrift trust, where land is conveyed to trust for the grantee and another with power of sale and limitation over to another if the grantee's creditors undertake to enforce claims against it, only a life estate or an estate until such contingency is granted. If the property is conveyed to a trustee in fee simple in trust for the beneficiary until he arrives at a certain age, at which time it is to be conveyed to him absolutely, no spendthrift trust is created, but a spendthrift trust without vested interest is created where, under the terms of the trust instrument, the trustees may pay income for life to either the beneficiary or his wife, or the survivor or their issue, or any of them in the trustee's discretion. Rights of widow or beneficiary of a spendthrift trust or payment of income to her after his death are not destroyed or dissipated by the beneficiaries having induced the trustee to refuse to act as such for a time, because the testamentary proviso which avoided legacies to the beneficiary if he will or commenced any proceedings with the object of setting it aside. Next section, 190, resulting or constructive trusts. Where land bought with the money of one person is conveyed to another, the latter is a trustee for the former, and the extent of the money paid without any expressed agreement to that effect, the quantity of the interest held by the city key trust being the portion which the amount so paid by him bears to the whole price. Where land bought with the money of one person is conveyed to another, the latter is a trustee for the former to the extent of the money paid, without any expressed agreement to that effect, the quantum of interest held by the city key trust being the portion of the amount so paid by him. Where title to realty at a mortgage foreclosure sale was taken in the name of a defendant by the mortgagor whom defendant was assisting, the purchase was not a loan to the mortgagor. The trust resulting in favor of the mortgagor was of the interest equal to, but not exceeding, the portion of the total purchase price with the mortgagors paid. However, it has been held that the real estate purchased by a common fund is the property of the parties who contributed thereto and is owned by them in equal shares, notwithstanding the inequality of the contributions in such fund, unless the interest of some of the parties is otherwise fixed by competent agreement. Where a trust results in favor of one by reason of his payment of a consideration for real estate, he is entitled to a conveyance thereof on paying the amount due thereon, and he may maintain an action in a quiet title to such an estate, and when his title is attacked, he is entitled to protection of the court, although the legal title may have been put in another's name in order to keep the property away from his creditors. A person in possession of land and entitled to a resulting trust therein is protected in his possession and the title as against the mortgagees of the trustee. The rule that an after acquired title ensures to the benefit of the grantee under a warranty deed has no application where the after acquired title is purchased with another's money under circumstances raising a resulting trust. Covenants relating to the management and sale of real estate containing the declaration of trust which was signed only by the trustee cannot, in the case of a resulting trust, be considered as covenants or limitations of the estate of the city key trust, although they accepted the declaration, since the covenants are void under the statute of frauds. Where the interest, then he who paid the consideration is paid to the holder of the legal. Such income is held in trust under the usual obligation of trustees. One defrauded in connection with the stock subscription is not the owner of the certificate of deposit issued by the bank to a wrongdoer and representing the fruits of the fraud, except in the sense that the facts entitle him to an equitable remedy of impressing a constructive trust in his favor. Next section, 191, estoppel and waiver. A city key trust cannot question the validity of the instrument by which the trustee was appointed an acquired title after he has accepted the benefits of the trust. A city key trust who obtains possession of trust property in that character cannot at law deny the title of trustee, and after he has accepted the benefits of the trust, he cannot question the validity of the instrument by which the trust made by the trustee, or impeach the title or impeach the deed which he had accepted. Where one is allowed by beneficiaries to deal with innocent third persons in the capacity of trustee, they are stopped to deny his authority so to deal. A beneficiary is not estopped to receive a legal title due him by the mere fact that the trustee was clothed with the indicia of title. The absence of the other circumstances raising an equitable estoppel, the fact that the conveyance to the trustee of a resulting trust does not show that the grantee holds the legal title as trustee, does not estop the beneficiary to set up his equitable title against others, not purchases for value without notice. The beneficiary may be bound by a waiver of his rights as beneficiary made for the benefit of the trustee and of other beneficiaries. Next section, 192, mutual rights and liabilities of city key trusts. A, in general, the mutual rights of liabilities of beneficiaries are controlled by the trust agreement insofar as it makes specific provisions therefor. The trust instrument is controlling as the mutual rights and liabilities of beneficiaries thereunder insofar as to make specific provision therefore, where there are life and remainder men situs remainder men cestuous, each can affect his own interest by consent, but not that of the other. One beneficiary cannot consent for another in breach of trust, to a breach of trust, nor can a majority of the beneficiaries, either in interest or in number, bind the minority by the request or consent of the breach of trust be performed. One city key trust is not liable to another for the failure of the trustee to perform properly the duties imposed upon him by the trust. The rectals in the deed from one beneficiary to a stranger cannot stop the other beneficiaries. But when beneficiaries have joined in the conveyance of the trust property to a third person to satisfy the balance due between party and a prior beneficiary, they are thereafter estopped to complain of the transfer, acquisition of the adverse title, or interest. One city key trust cannot acquire rights in or with respect to the trust estate which are antagonistic to or will give him an advantage over an associate's in an interest. He cannot permit the land to be sold for taxes and acquire title to the tax sale, acquire title at a tax sale, and where several persons purchase land, title to which is conveyed to two of them who execute a declaration of trust that they hold in trust for themselves and the others, a tax title to the whole tract bought in by two of the other purchases will be deemed a redemption of the whole tract and will inure to the benefit of all city key trusts. Agreement as to income. Where a trust is created for the benefit of husband and wife, the fact that the income was disposed in the wife's name does not negative the existence of an agreement between the beneficiaries that should be jointly owned. But where it is shown that the husband voluntarily surrendered his equitable interest in such income to his wife, his administrators cannot claim the deposit thereof in the wife's bank account. Where a trustee of the Spencer of Trust bought a home for one beneficiary on agreement, his share of income would be charged with interest on the amount paid for the home, and the beneficiary later repudiated the agreement and demanded a full share of income without deduction, and the co-beneficiary refused to ask for a surcharge against the trustee, the co-beneficiary may not complain of reduction in his income as a result of an arrangement between the trustee and other beneficiary and repudiation by the latter. Separation or division of the estate. Where beneficiaries desire separation of trust funds, and such separation is not only practicable but economical, there can be no objection to allowing it, and City Key Trust can make a division of an estate consistent of personality without the consent of the trustee in such a manner as to each can hold in servility a separate interest, although they cannot serve the legal estate or give each other a complete title. Settlement of disputes. While a settlement of dispute among beneficiaries of a trust is favored in law, all interested parties must join therein. Transfer of interest to co-beneficiary. One beneficiary may transfer his interest on the trust to another beneficiary, and consideration for such a transfer has been held unnecessary. One City Key Trust may purchase the interest of another as long as no advantage is taken and the transaction is in good faith. A transfer by one of several beneficiaries of all his right, title, and interest to another does not in any manner affect the title and the state of the trustee or the inchoate rights of other beneficiaries. B, contribution and compensation. A beneficiary may be entitled to contribution from the trust fund or from other beneficiaries for money paid out of the protection of the trust property. Where one beneficiary has paid out money for the protection of the trust property, he is entitled to reimbursement out of the trust fund or to proportion contribution from the other beneficiaries who accept the benefit of his efforts. On the other hand, the beneficiary induces or profits by a breach resulting from a diminution of the trust estate should be to contribute out of the interest in the estate to make good the principal in favor of the other beneficiaries, and if one of the beneficiary converts to his own use the part of the trust funds, such amount to be retained out of the share of the income for the benefit of the other beneficiaries. The beneficiary of the trust who participated in the mortgaging the trust realty are equally liable as between them to pay a deficiency judgment resulting after foreclosure sale, and by an action by the beneficiary who paid such judgment to recover from a co-beneficiary his share of the common obligation is an action for contributions. The beneficiaries of a trust may protect the trust res by the payment of taxes and claim reimbursements out of the trust fund. In the absence of the express agreement, equitable owners under the deed of trust have been held disentitled to charge one another with the value of their lay or professional services rendered with respect to the care and management of the property or expenses in connection with or for the protection of the title. Section 193, Transfer of Estate or Interest of City Key Trust, page 96. We'll pick up there next time. So let's go to the Q&A.
Q&A session started.
Press star 6, star 1 to get in the line and raise your hand. Star 6, star 1. Press star 6, star 1 to get in the queue line, raise your hand, state your name, where you're from. Anonymous, you're unmuted.
Yeah, this is Rick in SoCal. How are you tonight?
Good, okay.
Good. Appreciate the efforts and the reading and so forth. I got a question for you. If I'm understanding correctly, the trust situation, I'm kind of new to this, so I started listening to you last week, and so I'm trying to catch up to all your thinking. But if I'm understanding what I'm hearing in some of the comments I've heard, what I'm gathering is that as the grantor on my trust, deed of trust and so forth, that as long as I provide 2 SOI events, that equals 1 NOI event. At that point,
no. It goes with it. You need an NOI and an SOI.
All right. So if I've served warning to the lender that I'm thinking of or preparing to make a change in the trustee, and I've given them 2 notices, 10 days apart.
The 2 notices are just for establishing a record of an act you're doing.
That I'm preparing to do. I'm alerting them. I'm sorry?
Well, they would be acts that you've already done. You want to create a record of acts that you've already done.
Well, what I've done is I've sent a notice to my lenders, the beneficiary, the trustee, who's the other one? Trustee, the lender, beneficiary, and what's the 4th one? Off the top of my head. Well, I don't want to bog everybody down.
What did you notice of?
Beneficiary. Well, that I was I needed them to perform and give me information on my loan, and that they needed to provide certain information, documentation, to the loan, that original documents. I wanted to see the stamp loan. I want to see the original loan doc, original deed.
Okay, what gives you the authority to ask for that then?
What gives me authority to ask for it? I believe that there was some fraud committed, and therefore I was asking them to present that information to me as the grantor.
Okay, do you have a case going?
Well, that's at the time that I asked for it, no.
No.
At the time I asked for it, I did not. So I sent a notice of certificate of service by notary to them back in April. Waited the obligatory days, gave them a chance to respond. They didn't respond.
Is this for a setup for a debt validation first?
No, I wasn't too much aware of debt validation at the time. I was just looking to extract my deed of trust from the note. And based on, I believe, the note was paid for. When I signed for it, based on HJR 192 and the fact that our signatures create the funds these days, since 1933 or whenever, my understanding was that my signature created the money. The lender took that note to the Federal Reserve, got reimbursed, stamped my note, the original note paid, and they proceeded to monetize.
What are you trying to do?
Well, the goal is to try to extract my deed, get control of my deed again. That's the goal.
So you want possession?
Yeah, I want possession, but I want to make sure I do it in a way that's legal and forthright, and with all the
the possessory title is the legal title, and that vests in the trustee, and he has all liability.
I'm sorry, I didn't catch that. It broke up. I'm sorry, what'd you say?
The possessory title is the legal title that vests in the trustee, and he's the one who has all the liability.
I'm not sure what the term possessory title is. What's that?
The possessory title is
whoever has the title in their possession.
That's the at-law side title. That's the possessory title. That's the party who has all the liability.
Okay, but that's okay. If I get that, then once I'm able to extract it, and the thinking is, once I'm able to extract it from the note and get control of the title, at that point I create a private trust and appoint my new trustee.
No.
Okay.
We go back to the signatures, the first signature. Mm-hmm. And the first signature would be, say, on the mortgage application for the purchase of the property.
Yes.
That is what we want to be the formation of the trust.
Okay, when I signed the note, I gave them my signature. After I signed the note, they created...
No. Back before that. At the escrow
sorry?
closing. When you signed the note, was it escrow closing? That was not the first time you gave the bank your signature. You made loan application.
Okay, loan application, 1003. Okay.
Yeah. You made a loan application.
Okay.
That was the whole thing that kicked it all off from there.
Okay, the loan app.
Signature on the loan app provided the funds for you at closing, because at that time there was no funds created. So they created funds on your signature in the application so that they had funds available to supposedly loan you. Mm-hmm. And then you did a signing of the note. But what you want to do is you want to go back to the beginning where it all started, and you want to encapsulate all the whole ball of wax under like one signature, one case number, one record, one title. Mm-hmm. Then you want to merge the asset with the debt under trust and extinguish and terminate the trust. Extinguish the debt, terminate the trust.
Well, to extinguish the debt, is that an A for V process, or has it already been extinguished because of the?
Has nothing to do with it. Merger. It's merger.
Okay. Again, I'm.
All right. Under trust, except for value is not trust.
Okay.
So you want to be able to identify what is the equitable asset title, and you want to merge it with the debt title.
Okay.
You don't need to extract anything. They're already there. You just need to claim them as such and merge them together and extinguish them.
Okay, merge the asset for title, you said?
Yes, merge the equitable asset title with the debt title.
Title with the debt title. Okay, and the debt title is the deed of trust I signed. Is that correct?
Yeah, that's mortgage. The deed of trust. Yes.
Deed of trust is the debt title.
That's the debt title.
All right, so I understand that. So what is considered the asset title?
Okay, you could use a portion of the trust assets, which would be the promissory note.
Yeah, that's where I'm confused. If the note was created by me, and I'm trying to extinguish the note, how?
No, you're not trying to extinguish a note.
I'm trying to balance.
That's a form.
I'm trying
the
to
lower
balance
form, which is the obligation or the deed of trust. That's the debt title. That's the lower contracts. And it's going to be merged in the higher security, which is the note. And when you merge the two together, they're extinguished.
Okay, so I guess I'm still confused when you say asset title. What is? I mean, I understand deed of trust because that's tied to the note. What physical document are we talking about when we say asset title?
The note.
The note.
That's an equitable asset title.
Okay, the note.
And also the application and all the other documents in the whole mortgage account. They're all yours. They're all equitable assets. Whatever you put your signatures to, all that documentation is yours. It's all equitable assets. So you're just going to take a portion of it. You're going to take the note portion, which is an equitable asset, a part of the total equitable assets. You're going to take that note, merge it with the debt, which is the deed of trust, merge the two together, and they cancel each other out. They terminate.
All right, so the process for doing such what is the process for doing such thing? What does that look like? I create a separate trust, a private trust over here on the...
Oh, a trust already exists. All you have to do is take control of it. All you have to do is claim it, prove it, press it, and execute it.
Okay, so I guess
already you just made it all debtor creditor. You just never expressed it to be a trust. You have to express it to be a trust.
What am I
never been expressed as a trust. So
what am I expressing?
It does not exist.
So how does that look when you express something to be a trust? How does that look? Because I'm just not seeing it.
You have Gilbert's law summaries?
I'm sorry?
Gilbert law summaries?
No, sir, I don't.
Okay, I would get that. It's $30.
Right,
Go to a local store.
Law summary? Gilbert's
law summaries, yeah.
Okay, and that's going to give me how to do trust merger?
It'll give you the basic elements that you need, because in there it tells you the cheat sheet is, I'll pull it up here.
Is that something that's online? I mean, or do you just go to Amazon typically, or?
Yeah, you can get it online at Amazon, I wouldn't doubt, or any bookstore, any law library might have it in stock.
Mm-hmm.
It's Gilbert Law Summaries. It's a series. It's called Trust. Edward C. Halbach, Jr. Edward C. Halbach, Jr.
Okay.
You want the 13th edition.
13th, E-D-I-T-I-O-N. Okay.
Yeah,
and it's called Trust. This is a series, and you want the one that's Trust.
Yeah, the ISBN number is 978
13978
0 314
314
18 112,
112
and then there's a -1.
-1.
Like
Okay.
20, but you want to go to, here's the key points in that whole thing. Page 6 is talking about relationships under Section C.
Okay.
Then you want page 18,
Page 18.
Section A.
Section A.
This is the important one. That's the elements of a trust.
Okay.
If you don't understand what the elements of a trust is, you're in the dark.
Okay. Well, that's what I got. That's where I feel like I'm in right now.
Right. Where you're at.
Listening to everybody. I'm just trying to gather the information. So, okay. Okay. So then, an SOI is a statement of interest.
Let me finish. I'll give it all to you. Then I'm on page 28.
Page what?
28.
28. Okay.
Section 104.
Section 104.
Talks about segregation of trust res.
Can I ask you a question? Well, you mentioned the word res. I hear that word mentioned a lot. What does R-E-Z or R-E-S mean? What does that mean, res?
R-E-S, that's the thing.
That's the item itself?
Yeah, that's the thing. It's a chattel.
The subject you're talking about, or the document?
It's trust res. It's the corpus of the trust. It's the equitable asset. It's the value, so to speak.
All right. So the res is the value, so to speak, of whatever you're speaking of.
Right.
Okay, just so I understand that terminology. Okay, res. All right.
All right, so page 30 then,
All right,
section 111.
111.
That's special deposit.
Okay.
Okay, now here's the next important one.
Okay.
Page 78.
78.
A, letter A.
Uh-huh.
This is methods of trust creation. Got to have that one.
Methods of trust creation.
Page 18 and page 78, probably the two most important ones in the book. They're the most fundamental, and if you don't have them, you're lost.
Okay, fair enough.
You've got to have the trust elements, which are intent, purpose, party, specific trust res. And then page 78 is method of trust formation or creation. That's, we use the one by delivery.
Okay. Right now, basically, like I said, I've sent, again, they may not, you can blow me out of the water here, but that's okay. That's what we're here for, is learn. So I sent a notice of intention to modify deed of trust, ask them to respond to, about 8 or 9 points. No response.
Can you give me a simple definition of what NTT really is?
Well, I don't have all my notes in front of me. I haven't memorized it all yet, but no, I don't have it off the top of my head.
This is one that should be able to take off.
New technology trust.
Yeah. What is that?
Well, it sounds to me, based on the 4 conversations I've heard on the phone, 4 phone calls I've been on, is that you're operating, you're teaching us, educating us on private trust and how to operate in a trust situation with trust law, and so that we are able to protect ourselves and our possessions. I mean, that's kind of the way I'm understanding.
That's the common view of everybody knows and understands about trust, and that's not what we're doing.
Okay.
That's asset protection.
Okay.
We're using trust as an offense.
As an offense?
Yeah. Here's the basic thing. NTT is nothing more than you're using the ability of a trust to merge titles in payment of your debts.
Okay,
that's what you're
the ability of a trust to merge.
Using the ability of a trust to merge the titles in payment of debt.
Merge the titles in payment of debt. Okay. I'll memorize that.
NTT is.
Okay.
We're not using trust to protect your assets. We're using it to pay our debts.
Okay.
Gaining control of the SETI key trust or the strawman account, and we're making a payment out of it. But what we're really doing is we're making a merger of titles which extinguishes the debt.
Yeah, I guess it's just hard to...
You need to identify what the two titles are, the asset and the liability, and you just merge the two together using the moving titles platform.
Moving titles platform.
Moving titles platform. And when you merge the two titles, you've extinguished the debt or paid for the debt.
All right, so moving titles platform, is that a process or is that a document?
Yeah, that is a process where you're going to identify or create a title of an asset or a liability, and you're going to claim it as yours.
Okay.
And you're going to use it on a UCC-1 to give notice that you've done that, and you're going to record it in the county. And the UCC-1 and the county recording are the two records to prove that you've claimed it, and it's giving notice of that.
So that's the SOI you're talking about.
Those two items are the two SOIs to substantiate your claim that they're yours.
Okay.
Claim it as it's mine.
And all right, so once you get those
here's my two public notices, my two public witnesses, my two public records, which point to my actual documents in the private. They're mirrors.
Right. And all you're putting on...
That's what moving titles platform is all about. That's it. Just identifying titles so that you can claim them, and now you can move them. So
now,
we move them. Like after we've moved them, we give notice again on a UCC-3 and another county recording, which is two witnesses or two records again, that we've moved the titles. And whoever has the titles has liabilities.
Okay.
So we're going to move the debt title along with the asset title, and we're going to merge the two of them in one entity, and all basic trust law says that any time the two titles are merged in one entity, the trust terminates.
So, in effect, it's kind of using GAAP accounting principles in a sense where your debit and liabilities or...
Well, not really, because GAAP accounting rests on value, and we're talking about valueless things.
Okay. Okay. Now...
Trust is totally in an equitable realm in equity, which is 180% different or contra to at-law public side, and it's backwards.
So are you suggesting, I mean, if I'm hearing you correctly, equity law is private?
Yes.
And not public?
It's substantive law. It's where all the substantive rights of the real man are. It's about rights.
Okay, what about, all right, now, I'm just trying to compare and contrast some things because I'm still learning your system. But I've heard it said on the creditor-debtor side that a creditor is in the private, but they are...
No, that's a mistake. I beg to differ that, and I'll argue that.
Really?
We've been thinking that's what we were doing all along, but I found out we're not. The only way that can be done, the only way you can access the private side is through a trust. And if you study trust law, you'll find that out. It'll become apparent to you. And you'll find out that we've been going on the wrong direction path with this debtor-creditor, except for value and all this other stuff we've been doing in the past. It was totally going the wrong direction. You'll be amazed.
Well, what if there's no actual title? What if we're not talking about a secured debt? What if we're talking about an unsecured debt? How do you merge titles in that case?
I create a title. I do a survey.
So if I had a student loan, how would you create a title on a student loan to make a trust act?
That one's easy because really there's a title already created with that one. Because you got an account of a name and along with a number, and that name and number represents the title to that account.
Mm-hmm.
And all I have to do is claim that name and that account number on a UCC-1 and a 3, claim it as mine, and now it's mine. And I've given public notice that it is mine. Now if it's mine, I can do something with it. I can move it.
All right, so now that we've claimed it, just walk me through the process. We've claimed it now.
Let's take something like a cup. I like to use an example of a cup.
Well, I like the student loan.
Because
it's all there. So if I have the student loan, if you don't mind, all right, you claim it on UCC1, and then you do the filing in the 3. But now I've claimed it.
Yep.
So how does the U.S. Department of Education know that?
Well, you got to claim it first in order to have the right to do something with it. Otherwise, you have no right to do anything with it.
All right, so I've claimed it. You and I, okay, we've agreed that I've claimed it, and I've filed my UCC1 and my 3, and I've made claim on the product or on the loan. So how do you go from that to getting it zeroed out?
All right, so now I'm going to claim the name and the title to be a trust, res, and then I'm going to do a special deposit.
Okay.
I'm going to that whole case, or that whole account, into equitable trust res. And what I've done was I've taken out a general deposit by withdrawal, and I've redeposited it as special. And now I got a trust account.
Yeah, but how do I write something on the coupon, or do I do something with the UCC1s and 3s? Do I send those to the U.S. Department of Ed? How does that?
Well, go to the downloads where we talked about the nature of deposits, and it's general versus special.
Nature of deposits.
Yeah, I forget which one that was.
And you said special and what?
I think it was in May.
But it was special, and what was the other option? SPECIA, special and?
General versus special.
General.
Everything that's happening today is general or special.
Right, that's in the UCCs. That's
well, it's all over. It's not just UCC, it's everywhere, everything.
Okay.
Even juris secundum, if you listen to me.
Yes.
The one you want is May 8th.
Okay. And so I'm going to switch gears again. May 8th. What happens? I know the UCC has some information on leases. How, if you really don't have, if you're leasing a vehicle where you really don't have an ownership interest but just a rental interest, are you able to do the same thing?
Yeah, because that was a general deposit, which was mistaken, and it's not a general deposit. It was really a trust. You just never expressed it to be a trust. All you got to do is express it to be a trust and make an execution out of it and pay the debt.
So you would do the same thing, create the UCC1 and 3 and file it and record it, and it's the same basic procedures.
Yes.
Okay.
But so all we're doing is we're taking titles and merging them under trust and making a payment, so to speak, but I don't like saying that because it's really not. It's merging titles and terminating or extinguishing debt. And we're doing it by the moving titles platform, which is just a process to claim and give notice of a claim and give notice of a transfer,
okay,
or deliver or method of formation of a trust.
Okay, I'm shifting back to mortgages for a minute. I had a sale date scheduled for July 7th. That was moved to July 12th. We got it moved again to July 26th. In the meantime, what we did is between the July 7th, well, last month, actually I filed a debt validation letter, which we think worked and got the extra extension to the 26th because they changed the date on July 1 to, they made the change and said, okay, July 26th is the sale date. My question is then, how long does it take, or how long do I need to give to execute the merging of the titles in order to have standing in case we have to get to court? Because
well, I'm going to say
just because
when you're sold, it takes probably just to form a trust.
Well, to merge the titles, you said I have to merge asset with the note. So I have to merge both of those in order to get control. So my question is, I know the UCC allows minimum on emergency situations. You can go about 3 days as a minimum amount. So you got 3 days.
You can probably do all this within. If you don't have to do debt validation, just form a trust and merge the titles. You can probably do that in a week.
You know, I don't have to give them any more time than that. I mean, just that's it. I can just do whatever I got to do in a week to 10 days, and it's done.
Now you pay for it on the private side, but now you got a problem. You got a process running on the public side, which is a foreclosure. That you got a problem. You got to stop that. You got to throw some kind of monkey wrench in the gearworks to jam that up and stop it.
Well, I've done that right now. I filed a lawsuit today.
Yeah.
So I'm sure they'll be served sometime this week. My process server said they'll definitely be served by Friday. So
I'd make sure you stay in order to stop all this and join them somehow, preliminary injunction, temporary restraining order, or whatever, to freeze that up.
Yeah, I filed a petition for information. I filed a, well, I'll tell you exactly here. Filed a number.
Hey, let's go on with trust stuff.
I'm sorry?
Let's just go on with the trust stuff.
Okay. I guess the question then is, when I'm able to merge titles, since I'm in the foreclosure process, or I'm actually getting ready to be sold, I'm jamming up the situation, but because they're not going to stop just because I merged titles.
That's right. Don't take that as misconstruement because they're not going to stop.
Yeah. So what I have to plan for, in my mind, and tell me if I'm incorrect in thinking like this, I've got to plan for at least a court date of some type.
Yes, you need to create a DIB hearing, which you're creating so far, that you can present a claim for a trust and then go into equity and prove that you've made a payment from your trust.
Will anything that I've done so far with these two notices that I sent out in April, the debt val letter and the second follow-up letter on the debt validation, should those be included in my claim, or should I not worry about that and just do the trust merger documents?
Debt validation under 9-210 of UCC just for the purpose of coming up with some kind of default, which gives me the power of the colorable authority on the public side to revoke the signatures on the contracts.
Right, because that's when they don't respond. If they didn't respond a certain amount of time, they're acquiescing. But then I give them a second notice that letting them know that they're in dishonor, and they haven't responded to my second.
That authority to revoke the contracts, now I give them a colorable way out. But I hammer them on the private side because I've already made a payment, but I give them the door open to back out gracefully and save face by the public way of bowing out gracefully.
Yeah, they're not going to want to go public with a trial if I can prove fraud and all the other stuff. I mean, if I have evidence of fraud and so forth, so they're going to want to settle, in my mind. Is that bad thinking or is that good thinking?
Anything on the at-law side that you're going to come in with is got a good chance of failing because it's like going in a casino. You can't win.
Yeah,
the odds are
judges.
The only way that you can win is going in for under substantive rights under a trust on a private side in chambers and showing the evidence that you're under a trust.
Okay. So I need to get myself I need to get myself a little more time so that I can buy some time and then get this other process. I've got a couple weeks to get this process done. I guess I need to get online and get all this information May 8th, or not May 8th, the other stuff that we talked about in the mortgages, and get that under wraps. Okay. I'll sit and listen to everybody else, and I appreciate you taking the time.
Okay.
Thank you very much. I really appreciate it.
Chris, you're unmuted.
Hi, Christian.
Hey, how's it going?
Oh, pretty good. There was a section that you read off that really got me going, and I think you started at 181 tonight. Is that correct?
Yeah, that was. Yeah.
Okay. Let me reiterate it. It says a trustee accepting a trust is stopped to contest the title of the creator of the trust to the property conveyed to the trustee, and to set up a claim to the trust estate against the beneficiaries under trust, or denying the title or estate for persons who benefit the trust was created. And you went into adverse possession. But what I was really pinpointing is that there was a part that you read off, and I think it might have been a little bit further than where I'm at right now, but it intrigued me because it fits right into the escheatment laws, that the trustee, not in any capacities, can touch any of the res for its own benefit or its own purpose. You remember that section that you read off?
Yeah, I remember reading it, but I don't remember where it was.
Yeah. Anyway, that's very important. That's a very, very important key to what we're attempting here, is that the trustee has to be at its utmost honor to what the grantor or the creator of that trust was, and that means that they can't dip and dabble into the funds for their own purpose or their own usages, and that corresponds and correlates exactly with the escheatment laws. And I just wanted to point that out. I'm going to go ahead and try to find that section that you're reading off so I can block that out for our use.
Okay.
That's all I wanted to say for right now.
Okay, next caller, you're unmuted. Dennis.
Hello?
Yes, go ahead.
Oh, am I on, Christian?
Yes, you are.
Oh, it's Paul, Australia.
Hi.
How are you doing?
Not too bad.
We've got a trust meeting at the moment. We're doing indentures. And we're using some old indentures, but we've really reworded them. Now, my problem with them is, are we actually doing the indentures when we're expressing this is a credit card example, by the way. So we're going backwards. So we're re-expressing the credit card as an express trust. Now, are we doing this non-pro-tunc? That means, are we writing the indenture as if we wrote it back then? So the language has to reflect it as being back then, not for now?
Yes, because that's when the actual delivery of the trust res took place.
Yep. Okay, great. That's what I thought. Now, the other thing that worries me is a lot of this trust indenture stuff we've been looking at has monetary values in it, like payments, has words like payment, income. Those terms worry me in the sense that you're kind of commingling if you use that, because if you go into a court of equity, you don't get any monetary judgment. You're only getting a judgment against a trustee for breach of fiduciary duty, not any monetary loss as such. So therefore, any references to like words like income, payment would have to be eradicated, and you only leave words like right, title, and interest in there. Would that be correct?
I don't want to keep certain things in there for the at-law side, so I could come in and make a claim, you know, for and that would be positive action. And then, well, the reason why a payment was made, but you guys don't have it, is because obviously the trustee must have breached the trust because he absconded with the funds, I guess.
Did a creditor?
Yeah, that's what he did, really, yeah.
No, but it's trust indenture. Wouldn't you get a claim against the trustee and then take out a separate action once you've got the judgment against them into the normal statute court to get an actual monetary judgment against them?
Yeah, I might do that on a second action, maybe later after I won the equitable one, or maybe ask for, you know, other equitable relief according to what the court would give me, and maybe they might give me damages, but then I could come in maybe with a second action and go in for damages once I, you know, because damages would be on the at-law side. But
that's right.
The trust indenture, I would gear it towards, you know, merging of the titles and extinguishment of the debts and obligations.
Well, that's what we've done. That's exactly what we've done. But therefore, if we're doing that, we really don't want to mention anything about getting any income that might have been derived off that credit card, because that's to me, that's putting it back into debtor creditor.
Yeah, yeah.
So therefore, if you're going to get
that credit card was actually the proceeds, and I'm going to claim the proceeds therefrom, and that's going to encompass what they would classify as being, say, income or value.
Use the word proceeds. Okay, that sounds good. Does that sound good, guys? Yeah, we're all nodding in agreement. Okay, great. Okay, so we'll use the word proceeds, get rid of the word payment, income, anything that construed to be money, in a sense.
Right, stick with
Yeah.
the indenture, especially with just instructions for private side merger, extinguishment of debt, and if the trust is breached, then I'm going to claim for a return of all that.
Yep. Yep. Okay, great. So keep it pretty loose in a sense then, but don't be too specific about money, or what we call money.
Right.
Yeah. Okay. Oh, great. Oh, that's good. No, that's what we thought, but we just wanted to check because we're writing them up at the moment. Oh, no, we've already mentioned non-pro-tunc. No, someone just asked a question, non-pro-tunc, but you've already answered that question. So we are doing it non-pro-tunc as if it happened back then.
Trustee being non-pro-tunc.
Yeah. Oh, and also another question they just asked me. The trustee, now, if you put in a document, you're declaring this probably the CFO or the CEO as a trustee, but maybe when you did this thing 10 years ago, he wasn't. So therefore, would you be very specific in a name, or would you just put in a title rather than a name?
I think I might want to go with a name.
What is, we haven't got the name of the original guy, we've only got the one that's there now. Maybe the name of the...
That you know of, because actually he's the head of the bank or whatever it was. But this guy presently, he's the one that's responsible for what's happening now, and really you're doing it in the now.
So he's a successive trustee?
Yeah. Mm-hmm.
Yeah. Okay. All right then. So we'll leave that then. We're just concerned about that as well, because that might drag us into the now and not take us back to the past. Yeah.
Well, maybe you could put name plus successors or predecessors.
Yeah. Did you say that, Dennis? You asked. Dennis is here. He wants to ask a question.
Hi, Christian. Hey, listen. When you name someone, would it be valuable to just put or successor or predecessor if they're going to stick to only having a person named as a responsible party in this case?
Yeah, we have like a heading that's to, and then it's the CEO name, the CEO or accessor CEO, and then we put on there also the CFO's name and the CFO's successor or hereafter co-trustees.
Oh, okay.
Yeah, that makes much more sense.
Yeah, great.
Thank you.
Thanks, Christian. That's about it, mate. Thanks. Thank you very much.
Okay.
Okay, we'll talk to you soon. You can moot us out, or at least you can.
Other questions? You're the last one on the board, so anybody else that wants to ask a question, press star.
Anyway, Dennis has got about 100 questions about the Brigalow Corporation.
No, he doesn't. The agreement that you wanted us to be a party to in relation to having the password for the calls or the previous calls, and the agreement seems to say that you want the right title and interest of all benefits that come from our education. Is that the way it was meant to read?
Okay, I'm not quite following you.
Oh, he's talking about the Skype, getting onto Skype, and from Skype we can get onto your calls through ForShare, and in there you've got a thing that we become the trustee. We have a code to get in. Yeah.
Yeah, password. You have to accept the confidence and reliance on. I'm giving you my intellectual property and trusts to be treated, without redistribution or abused. And if you agree to the trust, then as my protection, password, you get the information. Yeah,
that sounds reasonable to me. That's stuff we're studying, so you just sign as trustee. I can't understand what he's...
I don't have the language in front of me, Christian, so I'm just quoting it on the fly, but it seemed to say that you wanted any proceeds that came from our education.
Yeah, well, why not?
Yes, I could claim all the proceeds therefrom, but, don't abuse the process. I won't do any collections.
Fair enough. I understand.
I'm just using what I'm teaching.
Exactly. I get you. In that context, suddenly it's like, okay, fine. Because see, when I wrote back to Lisa, I said, I agree, but how are you going to determine the value? And because it seemed like...
We're not talking about value here. I'm not trying to collect value. I'm trying to collect trust res. if there's a breach.
Yeah.
That's what we've just been talking about.
Nice, nice. Thank you very much.
He's a New Zealander, you know.
Stop it.
He's a New Zealander. That's why he asks these questions. He's a sheep farmer, Christian.
Well, it all works down there too, so.
What sheep farming?
Yeah, yes, yeah.
Yeah.
He's getting all woolly on you now, Christian. Don't worry about it.
Now, has anybody else got any questions they want to ask Christian? It's a good opportunity. No? Yeah, I can't think of any questions, Christian. So when are we going to do the... I've got a question. When are you going to work out how we're going to do the birth certificate? Because that's the one, isn't it?
Yes, we're slowly working on that, yeah.
Oh, we have got a question. We're reading Australian trust law book and it's got in here, well, we're trying to find it. We thought we saw it. Can a trustee sue a beneficiary?
If the trustee saw the beneficiary trying to breach the trust in some way, I suppose he can, because he's supposed to protect the trust.
There's your answer. Yeah, thank you. Yeah, of course. Yeah. Okay.
That would depend on the indenture.
Yeah.
Whether the beneficiary is trying to do something outside the indenture, say.
Yeah. Yeah. Okay. Well, that makes sense.
Bad beneficiary. Bad.
All right. Okay. Well, that's about it. No, but I'll be very. To me, the birth certificate's where it's all at, because we have a friend of ours in the group. She's not here today, but she got information from someone. She won't tell us who it is. But when you go to court or wherever you go, the judge can pull it up on the screen and have everything you've ever done in front of him. It's
referred to on one of the calls you'll be familiar with as the judge's cheat sheet.
Yeah, I've heard that, yeah. Yeah.
Well, she actually confirmed that for us, that it does exist in Australia, absolutely 100%. So getting rid of the birth... I was just wondering if you went into court and the judge did say, oh, wait a minute, you've got your birth certificate. Oh, wait a minute, Your Honour, I'll put in a claim for that. And he might say, oh, but you've got a loan. Yeah, yes, Your Honour, I've put in a claim for that as well. Here it is. Here's my documentation. Because these are all the things you'd claim under that, the big claim you'd make, those inclusive numbers, which would form all the different trusts. So if he kept on asking you those questions, oh, yes, Your Honour, I'll put in a claim for that as well. Here's the evidence. And here's the SOI to that. So in a sense, wouldn't that become a bit of a dip here? What do you call it? A dip hearing?
Dip hearing, right. Mm-hmm.
Would you classify that as that?
Yes.
Yeah. Okay.
But I'd be careful of doing the termination of the straw man without first having some way, because you're going to lock yourself out of commerce, and you have no way of getting back in.
Yeah, I realize. But didn't you say get out of commerce anyway?
Yes, get out of commerce, but we're going to create an interface device that we can still maintain a foot or a door opening in commerce, that we can use the consumables that are produced, which are really the colorable titles that I need to gain access to the real stuff that I really want and need every day.
Okay. So how do you see that happening? What's your thoughts there?
Well, we form another trust, a public trust on the public side, and then an LLC that is the trustee on that trust.
Wait a minute. Come one step back.
That LLC.
Sorry, Christian, is that a statutory trust or a private trust?
A public trust.
That's your statutory trust?
Yes.
Okay.
Something that they can see.
Okay.
Public.
Yeah.
Because that's my interface back in.
And would the private trust control the statutory trust then?
Yes, in a roundabout way.
By lien?
Visibly, you don't see it happening, but the LLC on top of was trustee on that public trust, and then I'm, say, president of that LLC.
Yeah.
So would you have a lien from the private trust onto the public trust?
No. There's a cross-through device, which was a broker who takes your equitable private assets held in private trust on the private side, locks it up in the private, and then they generate a public trade on your private asset and generate interest, and the interest is then deposited into your public trust.
Oh, into the public trust, okay. Which is being run by an LLC.
Right, so they generate the credit or interest, and that looks like credit or interest on the public side, and you just write a check from a checking account that's owned by the trust, controlled by the LLC.
So you would you'd use an LLC for this process that hadn't been used for any other purpose, wouldn't you?
Right, that's its sole purpose, yeah, because I don't use any business transactions, I don't generate any profits, I don't do anything to lock me back into an income and get me back into effectively being connected to a United States business or trade, say.
Okay, so how far away are you away from this sort of verbiage or technology? Because it seems to be the critical one.
For the end of the year to have this done.
He's always after verbiage, Paul.
Well, I reverse engineer the verbiage. If you know the verbiage, because I'm not that good at it, but if I hear other verbiage, you can then change it and work backwards. You're sort of reverse engineering where it's come from, like when you read a book.
Where to get the verbiage, here we have corpus juris secundum. The verbiage is in there.
Is that?
I don't know what your body of jurisprudence is there, but you probably have some kind of corpus juris of some kind over there.
We've looked it up. We haven't really. It really comes from England.
St. James.
The Court of St. James.
Okay, it has to be somewhere. It has to be coming from somewhere. Some kind of, encyclopedia set of, where's your laws and principles? Got to be written somewhere.
I think we've got access. Yeah. I don't think we've got the equivalent of what you've got. There'd be something, I suppose, but it's probably all fractionalized in different areas, commercial law, statute, this law, that law. They break it all up, but they haven't put it into one big, concise book like you've got, I don't think, which, like you say, is an encyclopedia of the whole lot.
Yeah.
I don't think we've got that. I really don't. If we have, it'd be English.
Well,
anyway.
You might want to check further and see if you can dig it up. I would think it would have to be written someplace. I wouldn't think it would be, split up.
Yeah. Okay. All right.
General versus special. General is at law, and special is equity. It's the law of nature, which is equity, and of nature's God. That's at law or general.
Yeah. Well, in our particular, we've got a trust book here at the moment, Australian trust law book, and it actually uses American and English precedent. So we probably could use corpus juris secundum. So the trust law is, in this particular book, it does use American and English precedent for it. So
probably whichever one makes the most sense.
Whichever one you want to use, I guess. Over here, we can use what we like. So that's the way I see it. So maybe they haven't written it here because we just use yours. Or use the English one. Like Lewin is basically English, isn't it? That's straight from England.
Yes.
Yeah.
That's actually the first American we're reading.
So in a sense, the Americans used the direct English law anyway.
Yes, came from that.
Yeah.
Yes.
Here's something you'd know, Christian, or probably you might know. Trust law, as we understand it and practice it, how is it really used in the Mideast and Asian, not just countries, but whole regions and districts? Because you can have the Chinese and it'll cover several countries, or the Indian subculture, their model of the world will cover several countries, and the whole Indonesia, in the Middle East, that's at least 20 or 30 countries are covered in that Islamic model. And how do they deal with international trust and international trust law? Do you know?
Well, they would have to do the international. Now, I don't know about their local. I've got a book on China's trust, but I haven't read it yet. So. But
is it in Mandarin?
Yeah, I believe it was. Yes.
Is it in Mandarin or is it in English?
Well, it's English based on the Mandarin, I believe.
Oh, okay.
So, because it makes sense that if I give you a pen and say, can you give it back to me in 5 minutes, and I've just established a trust, and you don't give it back to me, you're in breach of trust, that is, by definition, an international phenomena. No matter which way you cut it or slice it, no matter which language it's in, it's a trust.
Yeah, I believe all the laws come from the Bible from the beginning. If we all came from Adam, you know, it's all biblical, just like it's universal.
Yeah. The word Indian giver is an interesting one, Christian, because in Australia we used to use this word Indian giver, and that means if you gave something to somebody and they turn around and say, "Oh no, well, I want that back," they'd say, "You're just an Indian giver."
Mm-hmm.
Have you heard that?
Too.
Beg your pardon?
We have that term over here also.
Yeah. So that's interesting, isn't it? That's a sort of a trust term, isn't it, really?
Yeah. But that kind of points to that you're not supposed to do that.
No, sorry?
Yeah.
That kind of points to that that's everything with a connotation. You're not supposed to be an Indian giver. You know, you're not supposed to want it back.
Yeah, that's right. Yeah, exactly.
So that's,
and then they have yeah.
But then that's really a trust term.
Yeah, I reckon it is. When I first heard you, I thought of Indian giver. When you did that pen example, I immediately thought of an Indian giver. Yep. I want the pen back.
Yeah, give me my pen back.
Anyway, I think they have more people on the calls, Christian, so we'll get off.
We're the last ones.
No, I don't think so. I think there are more now. So I think that's been great, having a great session with you.
Okay, thank you.
We so appreciate your work.
Yeah, it's great, man. All right. Thanks, Christian. We'll mute out.
Have our Skype addresses and stuff here?
But sorry?
Do you have our Skype addresses here?
Yeah, we've got them. Yep.
Okay.
Yep. I'm on them. I talk to Lisa every now and again.
Oh, okay. What's your handle?
Mine's my name, Paul White.
Oh,
I don't have all these cryptic ones that everybody else has. I just put my name out there.
And mine's Hey Dennis.
Hey Dennis.
Or R Dennis, one of those.
One of those. Yeah, no, we just use our normal names. Yep. Anyway. Lisa knows it anyway.
Okay, great. Thanks.
Okay, thanks, Christian. Bye now.
Michael, you're unmuted.
Yeah, I just want to give a heads up to the guys down south and also anyone else. They're still on. Is that you can't have two debtors on the UCC. You can only move one. So it's either the CEO or the CFO, one of the two.
Well, because I gave a CFO and a CEO, but only one goes on UCC one. Yeah, because the thing is that you won't be able to move them together. You can only move one at a time. Yeah. Then what were we talking about? We're going to combine all the people. We'll put them all like in a new title, and put an RA number in its place, and we could use the RA number as the debtor or the trustee. Well, the thing is, that's what I was going to do with my case over here, is just basically doing an addendum and just say all debtors, on addendum. That's what I was going to do. And I guess you can do the same thing with the CEO or CFO. Yeah, right. Okay. You just have to look at your particular UCC depending upon where it is. Washington State won't let you do it. You only do one at a time, and looking at some of the other UCC docs, they're pretty much the same way too. But if we're going to have multiple, like with my situation, and that's one thing I did want to ask you, is that I'm going with the mayors and the police department, or the police captain, and then the sheriff, and the city council. And I really shouldn't be doing the county or the city, because no one represents them. And then if I do the county or the city, then there's going to be too many trustees involved, correct? It depends how many you think you can handle. Well, what I'm saying is that they could, even though it's going to be to my advantage, but they could end up breaching the trust by divulging all this information to other people and putting it on the public side. So yeah, that's why. The trust, though. Pardon me? That would be a breach of trust, though. Oh yeah, but the only thing I'm looking at is possibly
once they do breach the trust, then I can come back at them on the public side in regards to getting damages after the fact because they breached the trust.
Right.
So that's the only reason why I would think I'm putting in the county or the city too, because they're the ones that have the deep pockets, and they're the ones that basically have the bonds. But on my order, everyone that's involved, I'm purposely going to request all of their bond information and their insurance, that be divulged or given to me. And then also in regards to that is that if there's any retaliation against me or my household, then that would also be a breach of trust. But I'll go ahead and work on that document and shoot it over you and let you take a look-see at it.
All right.
But I'm going forward with it too. So that's all I wanted to say.
Thanks, Michael. Appreciate it. Anonymous, you're unmuted.
Hi, it's Rick again, California. CW, going back to the mortgage thing, if we go to court on the public side, you say we're going to probably lose. But on the private side, you have a good chance.
At law.
Sorry?
Yeah. At law.
Right. So what makes the judges have more integrity in the private than they do in the public?
Because the law form's flip-flopped, and it operates at a totally something different that what everybody understands as to be at law. Runs on those equitable principles and applies to the court, conscience of the court. And those laws are not, all these other stinking rules and stuff. There's only, so many equitable maxims, and that's it.
So if the judge does not act honorably with my private under seal camera documentation that proves my case, if he does not act honorably, then we can basically attach a lien on his bond and so forth?
Yeah, you could, but that would be debtor creditor again. But, here's the 900-pound gorilla is when you're in trust and equity, the onus of probandi or the burden of proof shifts now to the other party, which would be the trustee.
Okay.
And the court of equity assumes from the get-go that guilty.
That what? Maybe you broke up right then.
The court of equity assumes from the get-go, right from the start, that the trustee is guilty.
Oh, I see. Once you provide the evidence.
It's already been done. The court assumes you're guilty. Now,
so
that's what is against you at law when they come at you. They assume you're guilty.
So after he's read your case in private, he comes to the bench, and the attorney's sitting there or standing there for the defendant, which is the lender. He's seeing them as guilty immediately.
Yes. In a court of equity, if you claim and prove trust, automatically then the burden is that if a prima facie case has been made against the trustee and the trust has been proven, there is a trust, then the trustee is presumed to be guilty in a court of equity right from the start.
Oh, okay, that's good to know. Switching gears, in trust, last week I mentioned that we had, a group of us had actually did our Tim Turner docs, and we're on Section 2, sending all that stuff out, the bonds and all. And you said that's all public, but you did say there's a remedy, and there's a way to make that private. What I'm trying to understand is once something is made public, it's recorded. Even if you take that same item and then put it into a trust, the original recording would still be in the public, would it not?
Well, what it is, anything in the public is a general deposit.
Okay.
If it wasn't expressed by a trust, it's all general. And that gives rise automatically to the debtor-creditor relation.
So, but the technology you have to take the Turner docs out of the public, so we should probably complete the Turner docs and then go ahead.
Yeah, I don't recommend doing any of the debtor-creditor stuff because really what you have to do is you have to undo what you did. And why would I want to create more work for me to undo more? So I'm creating a bunch of debt that immediately I'm going to extinguish. Why should I even do that?
Well, I didn't know that. So, okay, so basically your technology for undoing the Tim Turner stuff is basically amounts to undoing what you've already done.
Yep, yeah, it really serves no purpose.
Okay, and I can't recall, did you mention that there was a certain or specific call or date that you spoke about that, or if not, is there something?
Mm-hmm. If you've been catching it, I've been talking about it all the time.
I'm sorry, it broke up again. I'm sorry, you said you've been talking about it, what?
I've been talking about it all the time.
The Tim Turner stuff?
Well, no, I'm not labeling Tim Turner stuff. I'm labeling all debtor-creditor stuff.
Oh, in the same file, okay. It's all the same.
Which encompasses Tim Turner's and everybody else's methodology under the debtor-creditor stuff. Because what you're doing is you're just creating a lien, which is you're creating a debt, and then that's just something I got to take care of under a trust and merge it and get rid of it. So why should I create it to begin with?
All right, so we should basically, is there a specific?
You got to choose which methodology you're going to use. Are you going to use trust and merger extinguishment of debt, or are you going to use a set-off under GAAP, under mounting debt principles, compounding debt more, and possibly get it discharged that way?
Okay, to get something that's more, to get information that's more direct to undoing the Tim Turner process, is there a specific call we should go back and look historically, or is that just something in general principle we should try to look at?
Just cancel everything that was done under debtor-creditor as creating a lien. If you've already created the lien, then that's a different thing. You'll have to take that title to the lien, and you'll have to extinguish it by merging it with an asset on the equitable side, on the private side.
Well, what I've done is we sent in the surety bond and the birth certificate that was stamped. Basically, that was it at this point. We haven't sent the indemnity bond or anything else in.
Well, any bond that you've created, you'd probably have to merge it and extinguish it.
Okay.
Because everything we created under the negotiable instruments, with the negotiable instruments, which is NDIs, negotiable debt instruments,
right,
under Article 3, then that is compounding debt, whether or not we realize it or not. And that's really not zeroing the count and touching the private side like we thought.
Okay, and switching gears.
You have to understand trust to get that.
You broke up. Something about trust, what?
You really have to understand trust to get that principle.
Okay.
How is it that we're only accessing the private side through trust?
Okay.
Well, I can answer that really, really easy, because don't we all call it a SETI key trust? And isn't a SETI key trust a trust? Then how can you access a trust? Because it says in Corpus Juris Secundum, I think it was 161, it said, if you claim a trust, you must treat it as a trust from there on in.
Right.
And we're not treating it as a trust, trying to get into this trust account and create bonds and set-off instruments against it and claim that we're a trustee on it when you don't even sign it as trustee.
Okay. Okay, that makes some sense. I appreciate that. Now, switching gears again to another subject that you were just speaking of in the last caller a little bit. We were talking about, and this is something you mentioned last week about, because I asked you how do you live and so forth and buy things and do things if you're not supposed to create debt. And you mentioned taking control of your straw man account by opening up another public trust and moving, if I understood correctly, the funds from the government straw man into your own private or public trust. So,
nothing cross the sides though. It's everything must stay segregated and not commingled.
Right. So my question then would be, how are you able to take it from your straw man trust that the government controls and put it into a public trust? And if you don't know the exact amount.
We're not. Nothing crosses from one side to the other. We don't take anything from the private and put it into the public, and we don't take anything from the public and try to put it in the private. If we did, we would breach our own trust. We would commingle.
Right, but it isn't the straw man public?
How do we get, so to speak, how did you create the interest on the one side?
Well, I didn't. The government created the interest, my straw man, with my Social Security number. Did they not? I mean, that's the way I understand it, is that when I was given a Social Security number, that straw man account was created. That's a corporation under my name. Is that correct thinking or bad thinking?
No, that straw man is just like a portal. It's an account through to assets being held on the private side.
Oh, okay, that's a different.
Look at it that way.
Okay.
So we're going to lock up the private assets in trust, and then we're going to what they call they block it. They freeze it, and then they incorporate it into a trade, and it's guaranteed to be there, although they can't touch it because it's trust funds. They can't have the corpus of the trust funds. No way. But they can generate interest from the lockup of it.
Right.
And the interest then is deposited on the private side because it's created from the private side. It's not created on the, excuse me, I goofed up there.
Yeah, because I thought you said you create a public.
Yeah, we create the interest on the public side.
Right, and then it goes into a private, interest goes into the private after.
Then it goes into the private trust after it's been created.
Okay. And then that's where the LLC is able to tap into that.
Yes, because it's private assets that are held up in trade, but nothing comes over into the public, but yet they create public credit and they deposit it into a public account for you.
Okay, but isn't an LLC a public entity?
Yes, and we want it to be because that's your interface, just like the straw man is.
Okay, so then, all right, I'm just trying, okay. So when you're transferring or locking up, is I think the term you used, you're locking up your government-operated straw man account, and they lock that up because then you're locked out. So
no. We are terminating that account.
You're terminating. Okay, but how can you terminate an account if you don't grab everything that's in it and pull it all out?
We are. We're going to pay all the debts associated with the account by merging it, and 1 penny of actual assets, say, applied to an infinite amount of public debt will be extinguished.
Oh. Well, that's interesting. Okay. Because
now, once we terminate the debt, the remainder that's left is going to be put into a new private trust account that we designate.
Right. But when we do that, we do separate ourselves from all future disability insurance and all that the government would pay. Am I not correct on that?
Correct. Correct. You are no longer associated, and it doesn't exist anymore. That's on the trust account.
So you have no benefits. Now,
you
what if
totally out? Totally out.
Now, what if you're a veteran and you're getting veteran benefits as far as your medical?
Goodbye.
That's gone too. Okay. Just want to make sure. So basically, when we do this, we better be making a lot of money on our interest.
That's what I say. You got to be able to. Before you terminate that thing, you got to have the other side all taken care of and everything all set up, and it all has to be done all at once, or else you're in big trouble.
Right, because you get, okay. That's just what I need to hear. All right, that's great. Thank you again, and I'll let whoever's next go up. Thank you so much. Appreciate that clarification.
601, you're unmuted.
Yes. Can you hear me?
Yes. Go ahead. Who's this?
Yeah. Earlier, when you was talking to Rick earlier, you were going over page 6, page 18, page 28 of information to really study on to learn the trust, and my phone had blanked out for a minute. I didn't get the book. Was that a Black's Law, Gilbert's Law? What were you looking? What was that information in?
That was book 90 on corpus juris secundum.
Book 90. corpus. Conduct. Okay, that's what I need to know. Thank you.
And I think we started at section... Section 180 on page 68 of the...
Section 1A, page 68.
68, yes, of copyright version 1955 I have.
Okay. Copyright version 1955. Okay. Thanks.
All right. Anything else?
No, I'm still trying to understand this. I'm still almost too confused to ask questions, but I'm picking up a little more every time.
Well, the basic thing is that, you know, the trust, we're using the trust to merge the title and actually pay the debts, or pay our payments, our expenses, our debts, whatever.
Gotcha. That would be basically you'd put every debt public debt you had on that, into that, covered in that merger, correct?
Yeah, do my electric bill, my gas purchase for the day, whatever it was, grocery bills, you know, everything.
And would you run that through that trust on a regular basis?
That'd be kind of a little bit difficult to do that, so we're trying to get a remittance device, kind of like a credit card, say, that you could use to, just like you would a regular credit card, make all your purchases through that and maybe just discharge the credit card, say.
Right. Okay. Gotcha. How far is that portion of the process? How far down the road are you anticipating on that, getting that far with the process?
I'm going to say by the end of the year.
Okay. But the merger of the trust and all this procedure has already been, the process has been completed on several individuals and several trusts. Is that correct?
Yeah, we had somebody discharged a couple IRS bills for like $57,000.
Okay.
And we've had some other successes too.
Okay.
We're starting to see some fruits of our labor starting to appear.
Okay, and I understood you was telling Rick earlier that he was in the foreclosure, and you were talking earlier, and you was talking if you got familiar with the trust, that you could basically set your trust up and merger your debts and all within like a couple of weeks, possibly.
Yeah, for that particular case basis, yeah, that could be done within that time frame.
Right.
But to encapsulate, to do the whole thing with the whole process, you got to have control of both sides, public and private, with all the interface devices in place and everything. Basically, just like I went over on the, 126, 2010 audio tape.
Okay. Do you have a ambassador that we could get in touch with to kind of walk through some of this information?
Well, if you come on the calls through the week and just kind of announce that you're looking for somebody to link up with, and you have a Skype handle, Skype account?
I don't. My son may have. He's not here right now. I'll find out. How do I Skype it to you, or do I just need to come on the conference call and give you the info?
Yeah, that way we'd link you up into the NTT groups and get you more access to possibility of running against a trust ambassador.
Gotcha. Okay. That's what I'll do. Thank you so much.
All right. Thank you. Marshall, you're unmuted.
Christian, how you doing tonight?
Okay. How are you?
I'm doing all right, doing good. I had a relatively good day today. I got a chance to go to the law library, spend a good number of hours there, and came up with some things that I needed. And couple of things that I had got. Remember, I was talking to you about form and procedure. So, per some of the things that you and I have been speaking about over the last, I guess, week or so, I went in today and was able to look at some discoveries. I have a discovery request for production of documents. Then I have a motion for protective order as responding to discovery. Then I have some information about a motion to compel responses to discovery. Motion to show cause order for contempt. I have a whole section of injunctions here.
There you go, injunctions. Yeah.
About the temporary restraining order. Now, the injunctions that I have, they came out of the North Carolina Practice Series, Civil Practice and Procedures, and I basically needed an outline for the temporary restraining order, the TRO that we was talking about, and I actually have my hands on that now, and the injunctions regarding the interlocutories and the mandatory injunctions, that's found in CJS, correct? In the the equity CJS, I believe it was.
I think I was in injunctions under CJS.
Injunctions under CJS. Okay. All right. Yeah, so like I said, today I went in there, got some information about, rules of evidence and proof of official records and counterclaims and just a bunch of stuff that we've been talking about, just so I can get my mind wrapped around what these things look like. And to tell you the truth, just like you told me before, a lot of it is relatively easy. I just had to see it and know exactly what needs to go inside of these documents as far as enforcement is concerned, because I know there's a lot of people out there who are concerned about enforcement, and it's one of the big things. Actually, another gentleman and I have been speaking about that the last couple of days, and that's one.
I think the enforcement is easy, but the hard part is to make sure that you get in the court of equity right.
Right, exactly. I can agree with that. Definitely agree with that.
Equity is going to take its course. It's got to. I mean, and then that's a different ball game now. It's been flip-flopped, but the trick is not to get pulled off track and to get into equity.
Right. But it just seems as if it's so much to even get into equity first in the at-law side, where you have to, jump through the hoops and the hurdles, the smoke and mirrors, to be able to get into private equity, because it's a lot of things that you got to put in, especially if you're already, being victimized by a foreclosure proceeding already. You have to, as you call it, throw a monkey wrench in a clockwork and jam things up on the public side of the court. And I guess that's what all these photocopies and things that I have here is for. Now, at first, I remember we spoke about this before, but a show cause hearing or a discovery, that should be like the first move you agreed with, right?
If you don't have a case that you're involved that they came at you with, yes, then I would say probably you come at them with, say, a show cause hearing.
Okay, great. Yeah, because the proceedings hasn't actually started yet. I haven't been served with any summons or anything like that. I've just been wanting to get all of my information together, and so I really haven't been on too many of the calls lately, because I've been doing a lot of reading and trying to wrap my mind around all of the paperwork and documentation that I'm going to have to come up with. But getting some help right.
The show cause hearing is going to simplify because you don't have to come in with a full-blown case.
Right, exactly, and that right there is what I'm focusing all my energy and my attention on, to be able to bring them in first. Now, let me ask you this question. This show cause hearing now, this still has a private side to it also, doesn't it? Because I would still have to be able to bring in my SOIs on a private in order for it to be seen.
Yeah, you'd have to have an NOI on the public and an SOI on the public, and with your NOI in the private and your SOIs in the private.
Okay, so while we're in, so this show cause hearing, we're not actually even dealing with a bill yet, is it? Is it just like a cause of action, I should say?
Yeah, your bill in equity is your cause of action, and that could be that breach of trust.
Okay, all right. So that's what I needed to hear. So we're still doing the bill in equity. Still have to get into the private side equity, but it might not even have to go that far if our bill outlines our equitable rights that are being breached from the beginning. We do a show cause and, a motion to compel, and hopefully that should take care of everything right there without a full-blown civil trial, or equitable trial, I should say, proceeding.
Yeah, because you're just on that one issue, say breach of trust.
Right. Yeah, because I went in today and like I said, I got everything about counterclaims and cross claims, and it's not that I don't want to do it. I mean, I wouldn't even want it to go that far. I still want to learn everything that I need to learn, but it's just more preparation and just being prepared A through Z just in case it does go that far, and whether or not I may have to come in with a counterclaim or whatever it may be. So I just want to be still prepared for everything, but I'm definitely, as of right now, focusing all of my attention and my energy on the discovery and the show cause hearing. And
the added advantage of that is that if you lose the show cause hearing, then there goes the case. Where if you had a case going on with a petition and everything in there, then you had a show cause hearing, you could always fall back on the counterclaim or the claim that you made.
Okay. So hold on. Let me get this straight now, because this might change things a little bit. You said, because the phone chimed out real fast. You said if I was to do a show cause hearing first and lose the show cause hearing, then that would blow the entire case, you said?
Yes, you lose the whole case. You can't fall back on, say, the main counterclaim or the petition that you have in there for the claim.
Oh, okay. So it does come with I wouldn't call it a negative side, but it comes with a consequence. That's a stiff consequence then.
Could be.
Yeah, because if that's the case, then you
wouldn't get a second chance.
Exactly. We wouldn't get a second chance, and we really would not be able to get into that private equity to show all of our. Well, no, we'll still be able to get in, but still in all, if we lose that show cause, then that's it, no second chance. Whereas we would be able to come in with a counterclaim if it was to go to a full-blown equitable trial.
Mm-hmm. Right.
Now that's something for me to think about there, because then that means for your show cause hearing, you would have to really come in with some strong, but I mean, just from our rights that we would be claiming in our bill, I would believe that those would be strong enough. So would it be a situation of practice that would allow us or put us in a situation where we might be able to lose in a show cause hearing, like procedure or something like that? Because the facts are the facts.
Yeah, I don't know of any shaky tools. I only know of shaky tool holders.
Yeah, right. One of your famous quotes. Okay, all right, so I would have to really sit down and figure out what it is that I'm more comfortable with. But like I said, my equitable rights are my equitable rights. So what would be the difference in claiming trust, proving trust, claiming trust, and actually showing evidence and record of a breach of trust? Like, how would that differ in a show cause hearing in opposed to a full-blown trial, because it's basically the same evidence, so it would be just as strong in a show cause hearing, wouldn't it?
Yeah, it's a little more complex, a little more in-depth to come in with a full petition, say, or a bill in equity, rather than just a show cause hearing. And I don't know, usually the show cause hearings are a little cheaper to get, but the difference of a couple $100 is, irrelevant, really.
Yeah.
Like a show cause hearing could be, say, $150, and maybe a full-blown case is like $300.
Yeah. Okay. Well, I don't know.
More paperwork that is involved, but then you got, if you lose the show cause hearing in a petition, you can fall back on the petition.
Hold on, so say that again. If we lose in a show cause hearing, you can fall back on your petition?
Yeah, you almost get like a second bite at the apple. You can come back in and say, almost like a second chance, like a safety net in a way. But it involves more work, probably, more knowledge, maybe.
Yeah, well, definitely not scared of the work or the knowledge, or not even say scared. I don't mind doing it. I just want to know, I just need to figure out for myself which way would be the best way for me to go about this, because being that it is, not that I don't have confidence in myself, in NTT and the application of it, but like you said, it's not the shaky tool, it's the shaky tool holder. And although I do have confidence and belief, I do also take into consideration that this is my first time doing what it is that I'm doing, and I don't want to make any foolish mistakes, I should say, just to be honest about it. I would rather put myself in a situation where I would have, just in case, now I'm not even planning on any losses or anything like that, but just in case I would have something secondary to fall back on to go at it again, like say a few months back when we first learned about, what CJS was talking about, that you must exhaust all of your at-law remedies first before you get into equity. And that's when, we were saying, okay, go into the at-law side first, and if you lose at the at-law side first, then you would be able to come into equity. But then a while after that, probably a couple of days or a week or so after that, we learned, we don't have to go into the at-law side as long as we can prove that there is no adequate remedy for us at law, and our relief is solely in equity. So it's like another one of those situations for me where I just want to have that extra safety net. So the money for the the full-blown trial, the extra $150, $200, that it would be well worth having that second chance, just in case, for a pro se litigant who is actually doing this stuff for the first time. But you actually got to start from somewhere, so it's not a problem. Everybody had their first time.
Yeah, we all had to learn how to walk by crawling first.
Exactly. Okay, so it's looking like, now had I known that, I would have been thinking a bit differently, but I definitely wanted to ask you about that, the discovery and the show cause hearing, and but without me sleeping on it and just, off the top of my head, it's looking like I would rather go. It may sound a little crazy, but it's looking like I would rather go like a full-blown trial where I would really be able to get inside of equity and, on the private side, and bring my SOIs in, and, along with my orders and my rogatories and my mandamuses and things of that nature, and make sure I compel the judge to do what he's supposed to do. And just in case, I would have a counterclaim.
Yeah, well, I think equity will compel the judge to do what he's supposed to do.
I think so also.
And we are equity, really.
That's right. That's right. Okay. One thing that I have learned is not to stress myself out over the situation and think that I just have to learn everything in the book all by a certain amount of time, but I'd just like to be very, very thorough with what it is that I'm doing, from the smallest, most minute, simplest things to the most biggest, extravagant, complicated things. So it's just the type of person that I am, but I just want to
give up.
Say that again?
We only lose when we give up.
Oh, yeah, absolutely.
When we fall off the horse, we lost when we don't get back up on the horse and try again.
Absolutely, absolutely. Well, yeah, like I said, I'm not trying to take any losses, and I'm doing my best and keeping my faith and my belief and keeping my studies up, staying and sticking with NTT, and I will get my relief. I have full faith and confidence in that. I just wanted to run by you, you know, the new information that I picked up. I was excited about being in there today, and just, you know, I was burning that photocopy machine up. It was just so many things. There's all kinds of other books on trusts and information that's in there. I was like, wow, this is just like a great place to be. But
how many elements were in the temporary restraining order?
Temporary restraining order? Hold on one second. Let me look at it right now. Well, as I'm looking at it, it has facts. Plaintiff is a citizen and resident of blank county, North Carolina. Then it has a first claim for relief. And the first claim for relief has 1, 2, 3, basically 3 points. I guess this would be where describe action of defendant of which plaintiff complains, describe injury to plaintiff, describe nature of prospective injury to plaintiff. So it's basically like the claim for relief is 3 short sentences. Some facts at the top, the claim for relief, and well, I would change this, wherefore plaintiff praise the court that a temporary restraining order be issued immediately, prohibiting defendant from continuing to engage in the conduct complained of. So, and like I said, this came straight out of civil litigation North Carolina practice series, and it's really basically a short form. It's complaint seeking temporary restraining order.
Okay, did you get into a section for causes of action? In another series, say?
Actually, yeah, I did. And this was probably a month ago, elements of civil causes of action in North Carolina. Yeah, I have breach of contract, civil conspiracy, debt validation act. I'm trying to see where the ones that I got about trusts. Unfair trade practices act violation. Yeah, they have a whole causes of action book. Is there any specific ones you think I need to be looking at?
Yeah, I would have looked under injunctions.
Injunctions. Okay, all right, so now I got to go back.
It sounds like what you've got is like the basic form, but then it looks like you're missing the elements.
That's why I'm glad I got on the phone with you and talked about this. All right, so let me write.
There should be one in there that says there is no adequate remedy at law. There should be one in there that probably going to say that you're being damaged. And then there may be 2 or 3 others that there may be 4 or 5 under the elements under that cause of action.
Okay. All right, so I need to get back and look under injunctions.
Sounds like you've got the basic form for the pleading of the injunction, but not the elements.
Not the element. You know what? And I got exactly what I asked for, too, to tell you the truth, because that's what I wanted. I wanted to see what the form looked like, but now I need the rest of the elements that go into it, so I know exactly what to go back and look for. Like I told you, it's once a week, so I blew my one day today, but so I'll be back in there bright and early on Monday morning, but just continue to do some reading until then. But so now I want to look under causes of actions, injunctions.
I think so, yeah.
Okay. And also, so that's going to be, hold on, let me write this down. Causes of actions, injunctions, and then I also want to look into CJS injunctions.
Yeah, now CJS I don't think gives the elements, although it may have in a roundabout way. I think it did talk about some of them, but it doesn't like spell them out like 1, 2, 3, 4, 5.
If I'm not mistaken, because I went over it that first time after we spoke about it, and I went to the law library, but I was, like, my main thing that I was looking for that day was
mandatory injunction.
Yeah, yes, exactly. And admissibility and inadmissibility of evidence. Like, that was real big for me that day to make sure I knew exactly, according to North Carolina practice and procedures, to get my evidence inside of the courtroom correctly, and, you know, just seeing it for myself about the records and signatures on the seal, and I have all of that information. So injunctions, the injunctions in CJS, I remember you recommended that it'll show you, like you said, in a roundabout way on how to put it together by the subsections.
Mm-hmm.
You remember that?
Yeah.
Okay, yeah, so that was one of the things that I'm going to look into. Again, just look into the subsections and the headings under injunctions and see what I can pick from out of there. And I also want to go to...
You're looking under corpus juris, also look under pleadings.
Pleadings.
Or plead. Yeah, that'll give you a good example of how to make out a pleading.
Okay, so, all right. So now CJS injunctions and pleadings or pleads, and then North Carolina causes of action, injunctions. Now, what about the bill? Is there a specific section in CJS about our bills in equity, or is it under the same thing under the pleadings?
Yeah, it's the same as the pleading, but then you might want to just take Black's Law 8th edition and just look under bill and equity.
Yeah, I did. I was actually chatting about that with Dominic a little while ago on the Skype.
Those 9 things are really in a pleading. They're talking about a pleading.
Bill and equity, Blacks. Okay, cool. All right, so basically what I got today was, besides, you know, the formats of the motions for discovery and all of that, I got some information regarding the counterclaims and assignments and the injunctions, but this is just the basic stuff. But what you just told me just now, the CJS injunctions and pleadings, causes of actions on injunctions, and bill and equity and Blacks, is seemingly what I'm really going to need.
Yeah, I would go in also while you're there, look under your local rules, your local state rules, and find where your injunction section is, and it'll probably tell you in there what specifically the elements are also.
Okay. Local rules and find injunctions.
That definitely will tell you the elements. And that applies to your actual local rules, where the one you find maybe as the state level will tell you generally maybe what the issues are in this, you say your certain DCA, or your elements are in your certain DCA, District Court of Appeals, say, and they're a little bit different. They switch up if they're like Florida. Like some have 4 and some substitute another one in their same 4, or some of them might have 5. I forget exactly now, but there's a little bit of variance in the DCAs depending on where you are and where you are in location to your state. At least in application to Florida here, I know that.
Okay, so you're saying that there may be a slight differentiation between my state and local rules?
Yes. Yes.
Right. And
currently, the state is all, say, 5 things, but then when you get into the local rules where you are, they may substitute one of those for, you may still have, say, 5 elements, but they have a different one.
Okay. Okay, so I definitely want to go to my local rules.
You got to make sure you go to your local rules.
All right, local rules, very important. I need to put an asterisk by this. Local rules. And what did you say DCA standard for again?
District Court of Appeals.
District Court.
So my local rules could be a little bit different. My first DCA versus in the third DCA. Although they both have 5 elements, say, but one of the elements may be something different from the other one.
Ah, great, great, great. And you know what? The young lady that was helping me in the law library today, she was very specific about making sure that everything she got for me was North Carolina based, and even certain situations she was correcting me. Well, yeah, you might want that, but we have one specific for North Carolina, and I'm going to get you that. And so that was real good. So I appreciate you sharing that with me too, because that's something that I just didn't think of, and it's really critical and important. So I think that's about it for right now. I got more work to do. I'm still going to go over what it is that I have just to, get the format in my mind, and as far as the captions and plaintiff versus defendant and everything that goes up at the top. I'm a visual person myself also, and I just needed to see it. Now that I see it, I know what it's supposed to look like. So now the next thing is just putting the correct verbiage in it and putting my facts and,
I know
right.
2 elements that got to be there. I ought to say the 4 or 5. One of them has to be there is no adequate remedy at law, and the other one is that you're being irreparably harmed and damaged. So
no
look
adequate
for those,
remedy.
Those
Okay.
are elements in a TRO action I know of for sure. And when you see those, you got probably the rest of the elements there.
All right. No adequate remedy at law and irreparable damage. Look for these 2. Okay.
Irreparable harm and damage.
Damage and harm. Okay. Look for these 2 in my local practice. Okay. All right. This is going to be fun. All right. Okay. Now, may I ask you another question? Just getting off of this topic real quick, and then I'll get off. Hate to take it back so far, but just one thing. Now, the UCCs, right? When we're doing our claiming on the UCCs, say for instance, now I was speaking with one of the other ambassadors about this yesterday, and I just wanted to run it by you also. When we're claiming our titles, like say for instance in my particular situation, the actual reinstallment contract that I have with the bank as far as the collateralized loan is concerned, it actually on the top left hand side of the paper, it actually has an actual contract number on there. So now my question would be, would I be claiming, because you mentioned it to one of the gentlemen that you were speaking with earlier. Now, I know we can create our own titles, and you said that, whatever documentation we may have from anywhere may have an account number on it or something along those lines, and we could actually be claiming those numbers also. So now, for this situation, do I want to claim the actual contract number, or do I want to make one title for my entire presentment and have that one RA number represent my 4 or 5 documents that I'm going to have inside of my presentment?
Well, does your contract number incorporate all the other documents within it? And you wouldn't have to create another one because you already got it.
Well, no, that contract number is just, but then again, it all started from there because that was the actual.
You got a loan number or anything that's different from the contract number?
Yes, yeah. Well, I don't know if it's a loan number, but it's definitely when you say loan number, would you mean account number also?
Yeah, the account number, yeah.
Yeah. The account number is definitely different from the contract number.
Okay, well, I'd say the account number then incorporates, or let's put it this way, you can specify and make it that way.
Okay, so I can use the account number or the contract number and have that represent the entire whatever it is that I'm doing.
Yes, because you've got let me see if I find it right here. So you have a mistaken general public relation nature and character with an identity of the survey being the strawman name and the account number. And let's say that's going to be consisting of all documents in the account, or all documents in the case. And then you could say specifically, say the note and the mortgage and the mortgage application, but yet it encompasses all documents. So the straw man name and the account number is the catch-all for all the documents, and specifically such and such and such. So now I could take the straw man name and the account number and use that as the trust res.
Okay. Now getting back to that straw man name, I think you went over this with Floyd a while ago, but I just want to ask you this question real quick again. When it comes to claiming our names, are we creating a numeric title for that also?
No, because what we're doing is we're doing a survey, and the survey consists of you want to change the nature and character of the deposit, and you have to do an identity change. And the identity is the most important thing. Okay. And the identity consists of the name, the boundary, and number three is whether it's public or private.
Did you go over, you know what, and the funny thing is I've seen a lot of talk about the survey on one or two of the chat groups. Is that something that you went over on one of the calls at one time? Because like I said, there was a good 2 weeks that I wasn't on any of the calls because I've been trying to absorb this CJS trust and CJS equity.
It might have been one that you missed, yeah.
Okay.
So it sounds like we talked about this quite a while back, though, I think.
The survey?
Yeah, I believe we did. We talked about it probably about the same time around the general deposit area.
Okay.
So that's been at least about, I'd say sometime in May, I think.
Yeah, wow. I think, yeah, I must have missed that because I'm not too familiar about the the surveys. So if anybody out there knows, like any of the TAs, if you know exactly which call that might have been, if any of you might know, I really would love to get my hands on that information because I know claiming of the names is something very, very important, and it seems as if it's a...
Right, if you're going into Corpus Jurisdicundum at the library, pull up the one on boundaries.
Boundaries? All right.
Boundaries. And it will talk about identity, and it'll define it because that's where I got it from.
CJS boundaries.
And what you're creating a title by a survey. But since you already have a survey done per the birth certificate and all that stuff, you know, that's already been done. So all I got to do is claim it. So I'm going to change its name and identity, and it's by the way of the boundary, along with the name and the public versus public or private. I'm going to change that.
Okay.
But now this name, straw man name, and this account number that I'm talking about under this particular case is not the straw man Social Security number. The account number is not the Social Security number in this particular case. Because it's name and the number, your particular instance here, which is different from Social Security number.
Okay. Honestly speaking, I can definitely tell you that I do not have a clear enough understanding of that. So I really can't wait till I get my hands on this CJS and boundaries because I really want to understand that part. And
well, that's how we do a basic withdrawal from general and pull the title out and put it in as special, because we have to have a title which has to have a survey at one time, which sets up the name, sets up the boundary, and sets up whether it's public or private. But your general deposit has been public, so you've got your public in set up, and your name in the public, and your boundary set up in the public, and your whole identity is public and general in nature. So now we're gonna change that whole nature and character of that general deposit identity, and we're gonna turn it into special. We're gonna change it all. We're gonna change it from public to private, and we're gonna pull out the name, we're gonna pull out the boundary, and we're gonna put it in as special under trust. And you change the whole nature and the character of the deposit. And that's really changing the nature and character of a title. And the title could be the case.
So it's more than just claiming, withdrawing, and redepositing with the UCCs then?
Well, I'm just noticing what has already been done, and I'm really doing the changing by some other mechanism, by the formation of the trust, by doing the delivery, or doing a withdrawal by an order.
So now this withdrawal and the redeposit with the order, is this changing the boundaries that you're speaking about?
Well, all that was a mistake. It was mistaken. Mistake.
Right.
You guys misconstrued this because this was a mistake. You've mistaken. You can't take because this is a trust. You're not the beneficiary. Only the beneficiary has the right to take. And I'm correct. The mistaken trust res, and you guys think it's general, but all along from the inception, it's been special. Even if I realize it now, my intent is it was special from the beginning.
Okay, all right. See, now being that I wasn't too familiar as far as the boundaries are concerned, I was under the impression that changing this nature as far as the boundaries was like a different documentation or anything, but it's basically our order along with our public records of what we did with these UCCs. Yeah, kind of a way. So now let's talk about the boundaries. And for example, the birth certificate. Your mother came in as an informant and she did a survey. And she said that the doc measured the kid, weighed the kid, had blue eyes, put it all on a piece of paper, and that became the survey. Ah, okay. All right. Now I get it now. That became the title. Per mom's authority. Mom created it by order. Okay, so that one title is representation of all of the descriptions that you just gave. Yes. So when you describe it on a piece of paper as being whatever it was, all things encompassed in there, and specifically this, and that, then you have done a survey creating a boundary now that you can pull out of general deposit and put it in the special. Now I get it. Now I get it now. So that's what you mean by I would be able to encompass everything within this one, say, account number that I may claim, but I would have to give a specific order and a boundary with everything that's included within it for that one account number to be in representation of. Right. All right. Now I get it now. Okay. Still want to listen. And how this game's starting to be played. And you created it all. Yes. So, I guess in this particular situation, my account number. It's not like. I'm not too familiar with the mortgages and how that whole world really works. But as far as my particular situation is concerned, there was that one, how should I say, reinstallment contract that I basically signed, and bunch of other garbage. But that reinstallment contract is what they're trying to enforce upon or foreclose as well as what they're using as a means of foreclosure. So then that one account number or that one contract number does encompass everything, would it not? Because I don't recall any too much other documentation that my signature is on.
If it doesn't, you can make it so.
Right.
You're in control of the whole situation because you determine what the boundaries are, or what the boundaries consist of.
So with this particular situation, once again, the boundaries would consist of, I guess, the reinstallment contract itself and, I guess, a description of the res?
Was this off of bankruptcy?
No.
Oh, okay.
No, this was just a regular me going to the dealer, credit, money in hand for a down payment, I want a car.
Okay, so that's the main contract then, right?
Yeah, exactly. That's what I'm saying. Like, besides, the arbitration clause that's in there, whatever, that has my initials and my signature on there. Besides that one.
You make your payments, do you write a loan number or an account number in there that's different from this contract number?
Yes, it is. Yep. I always would reference it by the account number.
Okay, the account number is the whole thing.
Yes, that's what I was saying before. I just didn't know. See, like my original claim had, and that's the next thing I got to tell you what North Carolina did to me. But anyway, that's what I used, but I just figured, because I remember one time that you had said on one of the calls that I was listening to that, whatever numbers are out there are unclaimed titles for the most part. So I took it as, you know what, they can't claim it. They're not going to claim it, so I'm going to claim it just in case I may need it one day. So every little set of numbers that I saw, I was ready to claim them somehow, some way, and make them my own. But getting back to North Carolina, when I did my UCCs, right, and created my records, I did my one first and sent that in, and I had actually placed, just for, lack of better terminology, the way the form is set up, I had actually placed the CFO inside of the debtor's box, which would be the trustee, as per the nomenclature change. And, filled everything out, sent it into my SOS here, and waiting on them to give me my file number so I can continue with my threes and everything of that nature. Actually got it, but then I get a letter back from them quoting I forgot, I have the statute written down in here somewhere, where they don't allow you here in North Carolina a real man's name in that box. I don't know if it was because it was a non-UCC file and they were very non-descriptive, but they gave me a statute, and I actually went online and looked the statute up, and it basically stated that you can't put a real man's name in that trustee/debtor box or whatever you want to call it, because it will be construed as harassment and, some type of foul intent or whatever. So they actually rejected the filing, took my money, but sent me my paperwork back. So I felt that kind of odd and interesting that they didn't even accept it not one bit. So now, I'm going through Kentucky, and it's a whole lot cheaper anyway to do it that way. And, I've known people who've gone through Kentucky and never had any problems. But have you ever heard of anything like that? Any kind of a rejection of the UCC for that?
Yeah, I have, yeah.
Ah, well, yeah, that's what happened to me here. That's exactly what happened to me here. But, I get a way around that and go through Kentucky. But anyway,
the identity is really the survey of your strawman name and then that account number. And you're going to change that nature and character of that whole thing, and then specifically say that contract number.
Okay, so I want to use the strawman name, the account number, and the contract number?
Well, I would want to say with identity of the survey, strawman, account number, including all documents in the account, comma, specifically contract number such and such and such, and then any other documents that you know of.
Okay, cool, and that would be in my order.
Well, that's in your survey. That's your identity. that you're changing the character and the nature of.
Okay, so this survey is a separate piece of documentation besides the order.
Well, you remember the document we were working on the other night?
Yes.
That second paragraph contains the survey.
Okay, so that's what I mean. It's in the same document, but it has its specific place and it has its own space for you to speak of your survey. That's what I'm just automatically thinking that it's, you know, two separate documents or whatever, but it's in the same thing, and I haven't had a chance to really go through it as much as I would have liked to, but I see it's something that I need to do now because I was just...
Draw and redeposit instruction and order.
Yes, and exactly.
And what we're doing is we're changing the nature and the character from general to special by withdrawing the identity consisting of the name, the boundary, and the making it private. And therefore it's not in the jurisdiction, it's under now private. It's special in nature. All done by trust.
Right, all done by trust. Okay, good. I was definitely very familiar with the withdrawal and the redeposit, but it was the survey part that was new to me. I tell you, boy, like just when, I mean, I know I'm doing right by, you know, sticking to the books and doing a lot of reading, but like I said, these calls are very, very critical because a lot of things come out on these calls that are just like very, very pertinent and critical information that, you know, our processes for relief and things that we need to do. So once again, I thank you for enlightening my mind about that particular situation, and it's something that I definitely needed, and I'm going to have to listen to this call again when I actually get my hands on it. This one and night before, as a matter of fact. It was a couple of things you said that I really want to take some notes on and dig back into, but right now it seems as if foreclosure action is like the most important thing right now. I have to get back to the law library and get the rest of this paperwork together, but
well, when you get back to the law library, when you're looking up boundary in CJS, also look up under identity.
Identity, boundaries, and identity.
And probably want to look up maybe name. I forget, was there one under name? I forget, was name by itself? I think the name.
No, it is, yeah. I remember, I don't know where I seen it at before, but I saw one somewhere on some type of paperwork where they have a whole section or a book in CJS specifically named names.
Yeah, because it was either, I know boundary was one because I remember that's a short one. Identity is one that's a little longer, and I forgot about names, but yeah, you could be right in name. There may be a whole section on names that's pretty long, I think.
Yeah, if I'm not mistaken, there is a whole section. I remember seeing it somewhere. I can't recall where, but I said, wow, they even have names in CJS, and I remember saying to myself, like, that is definitely something that I'm going to want to get into. Is like, I have a whole list of goodies that I want to get into as far as these books are concerned. I just want to finish
Boundary is the short one, I know that. So if you scan through that, and when you find boundary and it makes reference to, say, name or identity, look in the footnote, and the footnote will probably take you, says, see identity.
Yeah.
And it'll give you the one to look for in identity, and it'll also probably say see name. So it'll cross-reference the other ones in the footnote.
Okay, cool. Well, basically what I'm doing here is, you know, playing my position here and just taking your advice on a couple of things on, you know, what should be prioritized over others. So that's definitely what I've been doing over the last, you know, 4 or 5 days, but I got a lot of asterisks on this page that I'm writing on right here, and a lot of this stuff is very, very important. So,
so this is how we change the defendant in a court case
to the plaintiff.
Yes, to be plaintiff. In fact, even withdraw him totally out of the venue so they didn't have jurisdiction against him.
Oh, say that again?
Pulling him out solely out of the jurisdiction, they don't even have jurisdiction against him.
Right, right.
You're pulling it out of general, which is public jurisdiction, into special under trust, under private. and they don't have jurisdiction on them by a withdrawal and a redeposit.
Okay, great. Once again, great explanation. Brought a couple of things together in home for me, so I really appreciate that. Yeah, I've been on for a good while now, so I think I'll click out and see if anybody else wants to get in. Is there anything else that you might want to tell me, Christian?
Not right now.
Okay, great. Well, yeah, I think I got a lot out of you already, so got a lot more work to do. Once again, I appreciate it, and thank you very much.
Marshall.
All right.
301, you're unmuted.
Hello?
Yes, hello.
Hi, yeah, almost fell asleep there. Not quite. Actually, the questions asked were really good. I had a question, and I forgot what it is now. It had to do with, what did it have to do with? Had to do with the trust, obviously.
We're talking about Dead Man's Trust.
Dead Man's Trust, that's right, yeah. We were reading today about part of the problem is that somebody mentioned on an email somewhere, says, quit calling it a trust, it's a probate, because they say that what they did was they killed the straw man, and now it's a probate case.
Something it wasn't even alive.
Yeah,
That's what I said, was how could it be dead if it was never alive?
But they converted it into a corporation.
But they converted it into a corporation.
And then killed the corporation.
And then killed the corporation.
No, you can't kill a corporation either. It never was alive either.
That's all just.
That's why you got to have a live man give him the signature to charge it up. That's the only thing that gives it life. Is a real man.
So we give it life even still, so it can't be dead, right?
Well, you know, how can a piece of paper, a form, or a process or procedure be alive? It's just you're being tricked to perform it for them. You're being brainwashed. You're mind controlled.
Right. Okay, that answered that question. The second question was discussions going on further and further and digging deeper and deeper and chasing more rabbits down more rabbit holes. We've all, through a whole lot of stuff, and we listened to one guy for about an hour and a half, about 2 or 3 hours a night. He seemed to have all the evidence together to validate that the Constitution itself was never actually ratified. But that's neither here nor there. What's important to us is that it seems that what's actually happened through legislation and other things that they've done, that everything is actually under the UN and no longer, and the Constitution ends up becoming a distraction, and because everything is actually under the UN, because as we read it, it seems to be true. So I was wondering if we need to begin to work with UN, shall we say, facilities, international facilities, instead of these bogus, we're finding out more and more completely bogus, based on fraud, based in fraud, having no jurisdiction, having no authority, and so on and so forth, these quote-unquote fictional courts.
International trust.
International trust. So we convert things into international trust then?
Good, yep.
Okay, so we have private trust, public trust, and international trust now?
For the statutory public side, yeah colorably.
All right. I still cannot seem to get my head wrapped around public and private, because even though to me everything is private, I have no problem being in public because I'm an honorable man, and I think that's why I don't conceive of the concept of hiding anything in business, because all of my business dealings is on the up and up, and I guarantee all the work I've ever done.
You have a business license?
I did at one time. I've shut everything down because this is my full-time job, I guess you might say right now, because I can't think of any more.
Down? No, that's the question. If you had a license before, you got a birth certificate, you had all these driver's licenses and things, you know, you can shut them down, but you don't. They're still there. They're still in existence. They're still on the records. There's still a general deposit. and you haven't withdrawn.
Sure. I'm one of these people that sees no reason to throw something away if it's useful.
Yeah.
I just want to make it useful. That's what, if you want to know my perspective, a lot of people are trying to, pay their debts off and get clear and freed, and I explained to them, I said, there's no way you can ever pay the debt off because every breath you take puts you further and further in debt to your creator, so forget about it. And so far as, like I say, why throw something away?
I disagree with that because your debt's already been paid by somebody else.
Exactly. But what I was saying is that we cannot get ourselves out of debt. We have our prices. The price has already been paid for us.
Yeah, because
but it says you have to ask and believe before you can receive.
Yeah, the Declaration of Independence says that you have all the unalienable rights. You always had them. Can't get rid of them. You're just being tricked to believe that you got rid of them. You still have them all. You never gave them up, but you're brainwashed to believe that you don't have them.
Well, also when you have two large people with guns and mace and everything else, and they're grabbing you and putting handcuffs on you and twisting your arm up behind your back in ways it wasn't meant to do, that becomes a bit of a reality too, not just brainwashing. They back it up with a little bit of physical intimidation.
Yeah, threats and coercion, right?
Yes, exactly. Now, on the mortgage thing, we are doing something, and we just noticed something today. I don't know if it's helpful or useful, but I'll throw it out there for other people, and you can say something about it. But we noticed that none of the affidavits that they have in there, there's at least 4 or 5 of them that are needed in almost every single one of them. But we've noticed that none of them have a jurat, which we looked it up under Black's Law, which is required. So again, they're filing fraudulent documents. We're simply going to do a motion to dismiss based on their fraudulent documents.
That may work. But like you said, they're going to everything being colorable in the colorable realm. You don't need what is it that judges are supposed to have? They're oath certified. They're supposed to have oaths on place. We're getting away from that. We're getting away from everything being colorable. We're getting away with the jurats. Even the president doesn't even have to have a birth certificate and born in this country anymore. Everything is becoming colorable. One big lie. All for the purpose of speeding up commerce.
That kind of moves to the very next level, which I was going to mention to the other person, hearing him say that he's doing a show cause hearing. And my experience has been anytime you do a show cause hearing, they've already got you nailed from it. They've got it preset, and it's just a matter of a dog and pony show. And be prepared. I think all of us need to be prepared to go to the next level and actually make them the defendants on the next level. I think we all need to be prepared to do that, to hold these judges accountable. And what was the other thing we heard? That when you appeal, you need to appeal to which is the only lawful court?
The appellate court, the tribunal court.
Yeah, the tribunal court, because only a tribunal actually has the power, at least under the Constitution, only a tribunal has the power to hear any of these cases in the first place.
What Constitution?
Yeah, exactly.
So what about the courts of equity? Because I don't hear anybody talking about equity. I don't hear anybody talking about trust. It's like something that's been totally forgotten. Everybody's trying to come into court and go on the at-law side. We're not trying to do that. We're trying to come in and go into the equitable side, which is a different law form. 180 degrees backwards.
Okay. I think probably what's getting in the way is the brainwashing. And of course, the last year and a half of studying has all been studying all the other stuff, and debtor, creditor, and all that other stuff, and the law and the legal system, and so on and so forth. And now I'm trying to get my head wrapped around the trust thing, and I understand the principles of it. I understand the mechanisms of it. It's just I don't fully understand how you go into a court and you know, we had a guy go into court and what was it called? Express the trust, and the judge threw him in jail almost immediately. Now, he didn't. Somebody told me the reason was because he didn't take it into the private chambers, which is what he should have done. So, you know, we make little mistakes like that, but we need to get our heads wrapped around.
Yeah, he didn't come probably under equity right away by stating it in the pleading there. We see that there's switches involved, and when those switches are in place, then, you know, if you claim some kind of remedy at law, that throws you right in at law, and you're going to get what you get at law, which is zero. So you can't come in and claim any at law principles, no statutes and codes, no remedy. In fact, just the term remedy is at law. Relief is in equity. So it's relief versus remedy. Remedy is under debt of creditor. Relief is under equity.
When you, is that a relief with an F or release with an S?
Relief, F. Relief is equitable under equity. Remedy is at law under the public side of the court.
Okay, I need to learn this all over again then. Start all over from scratch.
And don't get confused with the private side equity, which is nothing more than the statutes and codes again. There is a private equity, which was pre-1933, which consists of just maxims in law, which has got to do with everything with substantive rights of the real man. The at-law side doesn't have anything to do with rights. It's got to do with the forms and the process and the procedures, the rules, the statutes, the codes, totally different law form. So equity is really backwards the other way.
Okay,
and
so what is
law form.
So what is the ABC? Give it so that we can get our heads wrapped around an ABC of, you know, if we're doing this thing, obviously foreclosure is what I'm focused on right now, and also I will be focused on a tax sale. I guess I'll talk later about that when I get to that. But right now, it's a foreclosure seems to be the big thing, and I basically have very few days left, and I was going to do this dismissal thing based on their fraud and then move to the next level. But if you have, is there something I can do basically in a day and a half to learn this stuff?
No, not really. It's too much.
How long does it take to study this to get your head wrapped around it?
Well, I can't answer that either because, you know, somebody may grasp it right off, and then somebody, they may never get it. Some may take them 5,000 hours. I don't know.
Well, I understand because I studied everything I could about trust and making a trust and so on and so forth. The part that I'm having a hard time understanding is the difference between public and private, as I said before. Can you help me at least with that part of it?
I'm not going to explain public versus private.
I know you can't talk about the private. Can you talk about the private?
Well, no, I can talk about the private, but the private is what is the actual real substance. But the public is the illusionary, colorable titles that you have to go through and have to get access to the real substance in the private. That's the way they've designed it. The public and private came into existence per the mechanism of a trust. The purpose of a trust is to divide the substance into two, and the two is public and private. The public would be the legal title, the possessory title to everything, the colorable title. It is the 9/10 of the law, but it's still the liability versus the private, which is the beneficial interest, the invisible title, the right to the whole ball of wax.
because we're the creators, right? Now, wait a minute. Are we creators or are we?
Yes, we are. Yes, we're the grantors because grantor means creator. And we are mimicking God on this planet, whether we know it or not.
Right, I agree. We're co-creators. I got that. But somebody said that you use the term grantor in the public trust, or what do they call it? Statutory trust.
That's a statutory trust that I'm talking about. There are grantors over there also. But they are colorable titles. They are colorable trusts. They are public trusts. There are public trusts and there are private trusts. There's always this duality coexisting simultaneously in everything that's happening today. Public and private. And we've been trained to think in a one-track thinking, and we have all of us have trouble in a duality or more, a multi-dimensional thinking.
It sounds a little bit like double-entry bookkeeping.
Yes, it is, because that's what GAAP is based on, a trust. A trust is nothing more than an inverted T, and one side on the left is the liability side, the minus side, and the other side on the right is the plus side, the asset side. That's the private side. The left side is the public side. That's a trust. Draw a circle around it. The circle represents the perfect title of the whole thing, but then the trust comes in and splits it into half. It's got two things now, public and private. Legal title, beneficial title. And the beneficial title is the 1/10 title that makes up the 9/10 with the whole thing, the 10/10. But we think we always want the possessory title, the legal title, which is the 9/10. But that's the legal liability. And here you want the beneficial interest, which is the real ownership of the whole thing.
Well, we need to take hold of that 10% then.
Yes, and you take a hold of that. You want to get both of them, merge them both together, terminate the trust, and bring back the perfect title. Bring back the circle. Bring back the republic. Bring back the America. Bring back the common law. Bring back the equity. By merging the title, terminating the trust. Because the trust separated it all and put it all hidden into the public. Or excuse me, private, I mean.
Oh my God, I think I see what you're saying.
It's like a circle. That was the republic. Everything in that circle was the republic, America, common law, equity. And then the trust came along and like a sweeping line, it came up from the bottom all the way up through it, and then it separated right down the center, and now it shoved everything into the right. Now it's hidden in the private. And it created this other realm, the vacuum of nothing, the public, on the left.
So what you're saying, by capturing both sides and putting them in there, you eliminate the trust and bring it back into one
thing, America. America has been put into trust. The republic that we love so much has been put into trust. It's still there. But we got to merge the two titles and terminate the trust to bring it back. You can do that on an individual case with, say, a mortgage, or you can do it multiple cases or anything, or you can do it all in one fell swoop for yourself. And if we all went together and did it, then we could bring it all back.
Well, for instance, I have about 4 properties that have gone to foreclosure. You say I could do all of them at the same time?
Yes. In fact, if they've gone to foreclosure, you can still get them back, or at least the...
they've already gone to foreclosure and been sold. They've actually got sold in-house, ironically enough.
You mean the same party that was doing the foreclosure bottom?
Yeah, the ones that were doing foreclosure is just another branch of the same conglomeration that ended up buying it. And even they say in their documents that they didn't fully pay for it.
Right. Well, the trust still exists. You just never expressed it. And since it's up to you to express it, therefore it does not exist. It only exists when you express it. We need to be expressing trust. the ones that are in existence, but yet nobody's making any claims towards. He who claims trust must prove trust. Nobody's claiming trust, so nobody has to prove any trust. They don't claim trust, although one exists.
Well, they do. It's definitely a claim trust. Otherwise, how could they have trustee, substitute trustee?
But they never say anything that it's a claim for trust because they're not coming in and claiming trust. You're not saying anything that, hey, there's a trustee on a captioning up here. There must be a trust here. So if you do that, you've got to prove that there is a trust. But you see, they're not coming in and claiming trust.
All I have to do is claim trust then and say that there's definitely a trust here. And
no, you just can't claim trust. You've got to prove trust. He who claims trust must prove trust. Once you prove trust...
What's the easiest way to prove trust? Isn't it the transference of the res?
Yeah.
And once I claim it, once I express it, it exists now because I expressed it, and then I can evidence it because of the transfer.
Yeah, you must invest it into the public realm so they can see something of a semblance of a trust, at least a notice.
Do you have any of this, how to do this, any templates or something that I can use to do that?
Well, we've been talking about this since, for 9 months now, since 11/7/2009.
Yeah, well, I've only just gotten into it myself because I only just heard about it from another person on another call a month ago, not even a month ago, 2 or 3 weeks ago, and got invited to call, and I just, jumped on here. So I'm sort of, it's not like I'm completely ignorant, but it is difficult to go from what's in my head and when I may or may not think I understand to putting it into a paper format in order to make sure that the dots are there and the T's are crossed type of thing, and it gets very, very scary and paranoid because you don't want to screw up, and so you end up, doing nothing. You get a short circuit there.
Right.
If I'm doing it for somebody else, I seem to be able to do it much quicker, but when it comes to doing it for myself, it's like Bambi in the headlights.
Right, yeah.
Well, I want to learn it thoroughly so I can help myself and then, of course, help other people do the same process. But unfortunately, helping myself is much harder than helping others. But if I had some documents to look at that have been successful and worked, and I understand things when I read things, I do much better. Like when I read court cases, I go, okay, I get it, and then I can actually mimic what they did in that particular court case, which I've done in the past. I mean, that's how I ended up doing my temporary restraining order, which I had to do it 3 times, but I finally got it right, and I got my temporary restraining order once. But had I not referred to other cases, I would have been lost. And this trust stuff is, as far as I know, it's not anywhere that I can see.
Yeah.
I mean, there's got to be a million people out there who've learned from you, been filing this stuff and doing it and making it work. So there's got to be some samples out there. Some may be better than others. I mean, we've improved.
Right.
I've sat and improved on documents before.
Right. We are working on documents, but we haven't released them yet because we're putting them in the best form that we can get them in, and so that they're complete from A to Z based on everything that we know so far.
Right. Have people been using this to stop the foreclosures and put it all back into one bag and
they've taken what they've learned off of the calls, and then to whatever degree they've shoved it in to solve their particular problems. Some have had success, some have not had success. But I haven't been geared into creating documents. I'm more for getting the principle down to the point where everybody's got the basics, because you need to know the basics.
Right. Well, if anyone happens to be on the line and happens to have some documents that have worked, I would really appreciate it if you could send them or we could work together on it to truthmonger2, TRUTHMONGER2, the number 2, at gmail.com. I would very much appreciate it. Like I say, myself personally, I have 5 properties I sacrificed to get a large building which I want to use for training seminars, And in fact, I would offer you the same thing. It would be wonderful if we could get you this. It's a huge building, and I bought it completely on faith, and that's a good story in and of itself. And I believe it's supposed to be a school, and I would like to have some people such as yourself. I have some people very much interested in it right now, and, you know, to come out there, and I want to actually have a full-time school going on all the time. And it's perfect for, you know, doing presentations, mock courts, you name it, it's there. So it's in Oklahoma. It's in a little teeny tiny town of only 1,500 people. But if at all possible, it would be wonderful to have you come out there and you know, do some training.
Yeah, we're trying to get this all together so I can help the masses.
Mm-hmm.
And
well, part of what I was hoping to do is that if we can get the gurus such as yourself to train the people, and then those people become, shall we say, out of 100 people, we might get 10 really good people that can actually train other people, and that method, it seems to me, to be the best. Excuse me?
It's much more difficult than that. It's like it's maybe 10 out of 1,000, you know. And it's like the debtor-creditor mentality is blocking the understanding. It's like it's in the way. It's, you know, it's a hard concept, but really the concept is simple. I mean, in its basic understanding is NTT is nothing more than taking two titles and merging them in this payment of debt. That's not hard at all.
No, the concept's not hard. It's the actual doing it, practicing it, putting it into play. I mean, I can explain the baseball game to you, but you know, until you learn how to read what the guy on the mound is saying to the other guy, and you know how to move your hat, turn your hat, twist your hat, and do everything, all that crazy stuff, and spit to the left and chew the chew, and you know, the dust on the hands, and all that other ambiance stuff, which is more than just ambiance.
Yeah, it's a while to get down. Yeah, that takes a little while to get down. Yeah.
Well, exactly, and that's one of the reasons I wanted to open up a school type of thing, was so that we could, you know, with a group of us helping to perfect the unbrainwashing techniques first, and then the learning and actually going through mock trials.
Yeah, I find that it takes about 1,250 hours of study to where things start making sense. Whether that was debtor creditor, or whether that was redemption, whether it was except for value, or all, you know, that's what I find, at least for me.
Well, yeah, I've got at least that many hours into all that, and now I'm starting all over again with the trust thing, and I wish at this point I hadn't studied any of that crap, because that stuff is actually causing me problems, and if I had never got into that stuff, I probably could have grasped this a lot easier, because I make sense out of things pretty easily.
Well, I find that the debtor-creditor stuff that I learned in the past, because I can do all that stuff. I can do the except for value. I can put a lien against somebody in 3 seconds. You know, I can write an 80-page contract that'll get you caught up in a lien and still. But all that stuff was really getting me ready for the trust stuff, because, you know, I could see all this stuff really didn't work. It was like a 10% success rate, and I looked at everything from A to Z, every methodology out there. And when I got to the trust, the very last thing, it's, oh my gosh, this
light bulbs went on, didn't they?
Yeah, it's like the more I studied trust, it was like, this is the glue that holds all this stuff together. This is the foundation that everything is sitting on, and we've been walking on it all the time and never saw it. Yep. Never saw it. Everybody says it's a trust, but nobody's going down the trust law path.
Right. Well, that's what I want to do. I understand it in this sense. This is what I have to come up with little ditties to get my little pea brain to work. So this, I share it with other people who might have pea brains like me. And what I said was, there's no way that there can be any debtor or creditor, because they did away with money. So if there's no money, there can't be a debtor and there can't be a creditor. So there's only one thing left, and that is, well, I'm going to trust you to pay me in the future. So everything is done in a trust. Am I pretty close or what?
No, that's right on. That's right on. And everything else is an illusion, including the debtor-creditor.
See, for days was trying to get me to understand trust, but until I sat there and said it is a fact, because I do understand that it is a fact that there is no money, well, I'm smart enough to know that if there is no money, then there can't be a debt and there can't be a creditor. So there's only one thing left, and that is a trust.
Yep.
Alan.
And that's what they're coming at you with the trust. They're enforcing the trust, although they're not claiming a trust. Right. They don't have to because they're not claiming a trust. They're not proving a trust. They're waiting for you.
Yeah.
And here you create the solution at a creditor stuff, and that's what they're coming at you with, but they're enforcing it under with a trust.
Alan.
Yeah.
Hello. This is Floyd.
Hey, Floyd, how you doing?
Doing good. You're welcome to work with me anytime you want to. Christian works with me all the time, and
that would be wonderful, Floyd. I'll bother you and not Christian then. How's that?
Well, that's what I'm here for.
Okay. I was also hoping that some of my I've always found in the past that he who asks the stupid questions is loved by all the other stupid people out there.
Well, welcome to the stupid club.
Thank you very much. Appreciate that. Daggone it, I'll figure this out sooner or later, you know.
Well, I'm still asking stupid questions, too.
Well, I always try to tell people I've got me a third grade education, so, you know, here we go.
Yeah.
But still, I'd say that a third grade education is better than a college PhD.
Well, at least it's an education.
Yeah, it's an education in common sense, which unfortunately I think most people with PhDs don't have anymore. They've lost it.
Well, it's educated away from them.
Yeah, well, you know what, I think I said this to people I notice. A lot of people don't have any college education. I try to alleviate their anxiety by asking them, would you like a college education? I'll give you one here in about 30 seconds. And they go, okay. And I said, all right, I want you to picture something that's alive, something that's real. I want you to picture it. And they go, okay. And I said, you got it? They go, yeah. I said, now picture a box. I said, now take that live, real thing and stick it in a box. Close the lid. You got it? Okay, now I want you in one word to describe and label that box, what's inside. Got it? They go, yes. Congratulations, you just graduated from college. Because in my opinion, that's exactly what college does. It teaches you to take that which is real, which the Creator created, stick it in a box and put a label on it so you can throw it around and deal with it, and it's not real anymore.
Yeah.
Anybody got any objections to that?
No.
Well, then I guess everybody here now has a college education.
Well, anyway, you have my number, so you can call me, at any time. And the basically the same thing that we went through when I talked to you. Christian has made it clear to you now that which you were kind of fuzzy on. So you have to hear this more than once.
Agreed.
Yeah.
Agreed.
And that's why it's real important for you to get on the calls every time you can, because you're going to learn more. You're going to learn more on these calls than you will just about any way I can think of. I mean, you have to read too, but the calls really clear up a lot of things, and then you can get on and you can talk to Christian just like you're doing tonight.
Yeah. I really appreciate it too, Christian. I very, very much appreciate you helping not just me but everybody else out, because whatever I learn, like I say, I intend to pass it on to as many people as I can and help these people out there that don't even have the ability to comprehend what we're doing. What I want to do is be able to make it available. My personal opinion is we need to make it available to the least of us, because I believe that's what it said. As you do or allow to be done unto the least, you have done unto me. So I kind of like follow that in my life. So I appreciate you, Christian, very much.
Okay, thanks.
Yeah, you're not alone on that, Colin. I think Lisa appreciates him too.
You think? I don't know if you have any more calls, but I'll mute myself out and let some other people ask some stupid questions, and I'll listen in and learn.
Well, actually, I do have a couple of questions myself, Christian. I was wondering, I was found guilty in court yesterday, and So now I have to come against the judge with a breach of trust, and what do? I do a mandatory injunction in equity, or what is my next step?
Probably another DIB hearing with a court that would, you're going to bring a formation, claim the trust, prove the trust, and then, like you said, some kind of injunction to stop it, and then the mandatory injunction to get them to perform the trust.
Well, is the mandatory injunction the second step then, or what?
Actually, it's the last step, because that's going to be issued to the trustee when you win.
Okay, well, I'm a little confused about court procedures here, so I've been listening to Marshall, and I was trying to pick up some things from him.
I was just going to say, you and Marshall probably, going to be about the same situation there.
Yeah. Maybe it'd be a good idea if I talk to Marshall then and see what he's going to do, because I'll have to probably do the same thing, because I know that I have to get in through the color on the colorable side to get into equity. My advantage that I did have is that I did claim trust right away, and I even signed the ticket as grantor beneficiary. So I started forming my trust right away.
And I give this of a breach too, and then an opportunity to cure.
Would that be one of the first steps? Would be to notify him of breach of trust?
Yeah, breach of trust with opportunity to cure.
Okay. All right.
And then a DIB hearing order of equity.
A DIB order for to hear him. A DIB order for equity.
Yeah, DIB hearing in equity to.
Okay. DIB hearing in equity. Okay. So I'll have to. That would be kind of like in the form of a notice, the DIB hearing.
No, that would be an actual court case.
Oh, that would be an actual court case. Okay, so how would I form that exactly? Would I have to, like, say, pay money, like put some money in and bring a charge against the court, or is this just an answer? Would I be putting in something like an answer to the court?
The first thing you said, the charge against the court, yeah.
Okay, so I'd have to. So actually, what I'm doing is I'm putting in a counter, like a counter suit or a counter claim.
Yeah, your bill in equity, your counterclaim.
So when I get the notice that I owe them that $115, I take that and I turn that into a trust res and turn that into a counterclaim.
No. The trust should already be formed, and you just need your documents to.
Yeah, the trust is. Yeah. Okay, so when they notify me that I've been charged and as guilty, and I owe them $115, do I take that and put that in as?
I would make that as a second, say, trust res deposit into the original trust.
Oh, okay. Okay. That's what I was wondering. Second trust res deposit. Okay. Now, okay, you're gonna. Well, maybe I could get Marshall to work with me on this and see if he'd be willing to help me, because this is not something I'm used to doing.
You two could collaborate together and.
And maybe I could get Colin to help me. He sounds like he knows more about court procedures than I do. Yeah, okay, I'll work it out. But I got kind of an idea of what I want to do, but all I need to do is get the procedure down because the trustee hasn't paid the bill.
Well, it's time for a breach of trust then.
Well, actually, that's true because he's telling me that there's a bill due for $115, and I already gave him the authority to pay it.
Yeah, well, here's my bill for the breach of trust, my bill in equity, so.
Okay. Okay, well, that's all I have for tonight then, I guess.
Okay, it's after 1 and almost 2 o'clock, so I give up for tonight, so.
Yeah. Okay, well, it's been a long day. Well, thank you, Christian.
Okay, thanks, Floyd. Okay, thanks all for coming on. This is Wednesday call tomorrow night, yeah. Okay, so we got 8 p.m. Eastern Time on TalkShoe. See you all then. Have a great night.